Today's meeting really highlights the difference a majority makes. Last Congress, as President Trump moved to terminate DACA, the Republican Congress blocked legislation to protect the Dreamers from even getting a vote. Over and over and over again, despite 80% of Americans saying Dreamers should be allowed to stay in the United States, 80%. But this Democratic majority is different. We have this radical idea that the People's House should actually reflect the will of the people. So today we are moving forward with H.R. 6, the American Dream and Promise Act. This bill would provide lawful permanent residence not just for the more than 2 million Dreamers in the United States today, but also those benefiting from deferred enforced departure and the hundreds of thousands of immigrants with temporary protected status, or TPS. TPS recipients are people who have fled their homelands because of natural disasters or dangerous human rights conditions. In some cases, they have been here for over 20 years. If you're a TPS recipient, you have to register with the federal government every 18 months, and you have to pass a background check every 18 months. Every 18 months. I don't think there were those in the president's cabinet who couldn't pass that kind of scrutiny. But President Trump and others act as though immigrants are some shadowy group to fear, rushing to the border to transport drugs and commit crimes. But here's the truth. Immigrants are our neighbors, our friends, small business owners, teachers, lawyers. In 2016, immigrants made up all of 6 of America's Nobel Prize winners across economics and science. And I could go on and on and on. This administration may have thrown the lives of DACA recipients, DED beneficiaries, and TPS holders into chaos, but we are committed in the majority to giving them the lawful permanent residence that they have earned. So having said that, I now turn to the distinguished ranking member, Mr. Cole, for any remarks that he would like to make.
Thank you very much, Mr. Chairman. Not surprisingly, we view this a little bit differently and view the conditions that got us here somewhat differently. Today's hearing is on an issue that's been vexing Congress for the last several years. The bill before us today purports to grant relief to people affected by DACA, the Deferred Action Childhood Arrival Program. The bill also includes provisions relating to temporary protected status and deferred enforced departure. Despite what you may hear from my Democratic friends about the president's actions, this is in fact a problem made worse by the failure of Congress under the leadership of both parties to provide a legislative solution. It was Congress that failed in the first place to enact appropriate laws concerning people who arrived here through no fault of their own as children. It was Congress that failed to act on a permanent workable solution when President Obama initiated the program in 2012. As lawmakers, we had ample opportunity to come up with an appropriate legislative solution, and we did not do so. That said, we've reached the point at which finger pointing is irrelevant and nonsensical, whether it's at 1600 Pennsylvania Avenue or here on Capitol Hill. I would also like to point out that we are yet again missing out on a real opportunity for bipartisan solutions, which in my view is the only way to enact immigration reform of any kind, regardless of who controls the House or Senate. The majority has brought up another DOA bill, Dead on Arrival, that addresses DACA, but does so in a way that will be described as a blanket amnesty. While I, too, want to see a solution for DACA recipients, I don't think this bill is the appropriate solution. It provides incentives for people to keep crossing the border illegally and for criminal enterprises to continue to use minors to sneak inside this country illegally, knowing that their actions may well be wiped away in a few years. As the majority, I recognize that this is their right. But once again, it means we're considering a bill that cannot pass the Senate and will not be signed into law by the President. And make no mistake, neither the Senate nor the President will support a blanket amnesty bill nor one that does not address border security. What could pass both chambers of Congress and be signed into law is a comprehensive immigration reform deal, a bill to strengthen border security, to reform our system, to make it fair, and to provide for relief of DACA recipients. During our rules hearings back in January and February, I repeatedly told the majority that they need to work with the Republicans on immigration and border security. Time and time again, the American people have told us that they need and want stronger border security to prevent people from entering the country illegally. There is a real crisis on the southern border, both a humanitarian crisis and a security crisis. The solution to the crisis and the DACA issue is the same, a comprehensive bill that would strengthen border security, provides relief for DACA recipients, and ensures a fair and just immigration system. Unfortunately, that's not at all what this bill is, Mr. Chairman. I believe that we can do better. Indeed, our members should have an opportunity to make this bill better, both here in rules and on the floor, and yet you did not even do a call for amendments. You did not even want to see what ideas that members on both sides of the aisles had to offer. That is a shame. Someday, hopefully in the near future, I'll be speaking in favor of a comprehensive immigration bill here in the Rules Committee, particularly one that will help secure our border as the American people wish. But unfortunately, that day is not today. With that, Mr. Chairman, I thank you and yield back my time.
Well, thank you very much. And I just would say that this is not a comprehensive immigration reform bill. This deals with a small group of people, relatively small group of people who are here in the United States, the Dreamers who were brought here through no fault of their own by their parents. Some were infants when they were brought here. And TPS holders, I know a little bit about TPS because I worked for the former chairman of this committee, Joe Moakley, who actually wrote the TPS law. But in this case, the TPS recipients we're talking about have been here for over 20 years. And as I mentioned in my statement, they every 18 months they have to register with the federal government. They have to go through a background check every 18 months. They're the most law-abiding people in this community. And in 20 years, people get married, they have kids, they have businesses, they purchase homes. I mean, in short, they have a life. I've met a TPS recipient from El Salvador in my district whose daughter doesn't speak Spanish. He wanted to know whether or not the president expected him to bring his daughter back to El Salvador, which is one of the most dangerous places in the world right now, when she doesn't speak the language, the only home she knows is here in the United States. Or did he expect the family just to be separated? So this is a humanitarian matter, and I'm all for bipartisan immigration reform. You know, when President George W. Bush was president, I actually supported the immigration reform package that passed the Senate, that he supported. It wasn't what I would have written, but I thought it was a step in the right direction. Unfortunately, we could never get a vote in the House because the then majority refused to allow anything to come to the floor. So we're going to move forward here. I'm happy to welcome Chairwoman Zoe Lofgren and Ranking Member Collins. We're delighted that you were here. Anything that you brought in writing will, without objection, be entered into the record. I now recognize the gentlewoman from California, who's the chair of the Immigration Subcommittee, Ms. Lofgren.
Thank you, Mr. Chairman. On May 22nd, the House Judiciary Committee met in open session to consider and favorably report two bills that collectively comprise the bill that is before the committee today, H.R. 6, the American Dream and Promise Act of 2019. With today's meeting of the Rules Committee, we take another step toward enacting a law that will finally provide lawful permanent residence to Dreamers and another deserving population, long-term recipients of humanitarian relief known as temporary protected status or deferred enforced departure. Title I of H.R. 6 is the latest version of vital legislation that would bring certainty and stability to the lives of undocumented people who came to this country as children and who are American in every way except on paper. Many of us, both in and outside this room, have been working to advance this legislation for a long time. It's hard to believe that it was 18 years ago that the DREAM Act was first introduced, and yet despite bipartisan support in Congress, as well as the support of more than 3/4 of the American people, we've thus far been unable to get this bill enacted into law. It was also 18 years ago that the world experienced events that would ultimately contribute to today's immigration debate and lead to the need for Title II of H.R. 6. In 2001, El Salvador, devastated by two major earthquakes and still recovering from the effects of Hurricane Mitch, was designated for TPS, providing security to Salvadorian nationals in the United States and relief to that nation as it began in the long process of rebuilding. With this designation, El Salvador joined its neighbors, Honduras and Nicaragua, which had received TPS designations 2 years earlier. Around that same time, as civil war in Liberia erupted for the second time in a decade, approximately 10,000 Liberian nationals were granted DED. Since then, natural disasters and armed conflicts have continued to ravage countries around the world, and America has responded. Today, up to 417,000 people from 10 nations reside lawfully in the United States with TPS, and up to 4,000 Liberians have DED. More than half of these individuals have been in the United States for at least 20 years, building lives and raising U.S. citizen children. Dreamers and TPS DED recipients may have come to the United States in different ways, and they may have had different opportunities once they arrived, but today they are united not only by the passage of time, but also by the uncertainty of the future. In September of 2017, President Trump announced the end of the Deferred Action for Childhood Arrivals, or DACA program, an initiative of President Obama that provided temporary relief from removal and work authorization to approximately 800,000 Dreamers. And since that time, despite compelling evidence that conditions remain dire, the administration has announced plans to terminate the TPS designations for 6 countries, as well as DED for Liberia, although that has now been temporarily delayed. For now, DACA recipients and TPS and DED holders have been granted temporary reprieves while federal courts examine whether the administration acted lawfully in ending these programs and protections. However, temporary reprieves are not enough. Congress has the power to bring certainty to the lives of these people by passing H.R. 6. The bill provides a fair and reasonable opportunity for Dreamers to apply for lawful permanent residence with tough eligibility standards and discretion to consider unique situations on a case-by-case basis. To be granted permanent residence, TPS and DED holders must continue to meet strict eligibility requirements that already apply to them. All applicants must pass security and background checks and are barred if they have a serious criminal record. This legislation should not be controversial. The DREAM Act has enjoyed bipartisan support in the past with many of the same provisions. TPS and DED holders have been an integral part of our communities, and they have been contributing to our economy for years. Quite often, we talk about the DREAM Act in terms of the impact on these young people, these de facto Americans, the TPS recipients in the same way. But this is also important for those of us who are not Dreamers or TPS recipients. We need these individuals to be part of our country fully and completely. We had a hearing about the Dreamers, and we had a young woman who was in medical school, and I thought to myself, why should that Dreamer not finish medical school and provide the medical care that she's set to give? We had a Dreamer who was a Rhodes Scholar, but he wasn't allowed to go to Oxford and represent our country because he couldn't get back in. It's good for America to pass these bills. I hope that we can approve them so that these individuals can be fully American and fully contribute to our country. And I would ask unanimous consent to put my remarks in the record.
Mr. Collins, welcome.
Thank you, Mr. Chairman. It's good to see you again. You know, it is interesting, and I think the perspective I will have to say as we start off here, the radical idea of it, and it's unfortunate because you and I sat over here and we talked about this recently. My last 2 bills have been closed rules coming up here, going to the floor, which, again, for something like this, could understand possibly even more on the last one. This one, though, is very concerning in the sense this is a big idea. But I was just sitting here. Before I get to my actual statement, something that you had said, Mr. Chairman, I respect, greatly. This is not a narrow actual bill. I agree with it's not comprehensive. I'd agree completely with that, but it's not narrow in the sense of what most would consider narrow. The population here is anywhere from 2.1 to 3.7 million in the Dreamer side, and that's, depending on how you want to count it. DED is about 500,000, and there's really no way to count the TPS. So we really can't determine a number on there because of they could have gone back and come back. So I would agree with you that this is not comprehensive. I would not agree in the sense, and we just respectfully disagree, that this is narrow. It's not, and because it's open here. But one of the things with my friend, Ms. Lofgren, we've talked about this on many occasions and had really good conversations about this. We come at it from different perspectives, but we know that this is an issue that needs to be fixed. And what is concerning here, from the comments that the chairwoman just said, is that this needs to be fixed, and at all costs, basically. Well, it was on the floor last fall to be fixed, when the Republicans had what was known as, colloquially, Goodlatte or McCall 1 or Goodlatte McCall 2. And when, again, we were both at deadlocks because Democrats didn't want to vote for it. Republicans, some of ours didn't want to vote for it. So we ended up in a position now to where we sort of went to the extremes again and said, let's design bills that only our folks will vote for. And that's really where we're at with this. And some on either side will never vote for this, on the left and the right. Some will never vote for any of these bills that we put forward. But the American people deserve for us to get to a point to where there is something in the middle that everybody can understand and we can get forward to. What concerns me about this bill today, and my opening statement reflects this, is that my concern about this bill is not those who deserve and need this help, which I believe that the DACA recipients do. And I've looked to try and find, is why I voted for the bills last year. What this does and what focuses me is what I saw last week, is this is simply opening up another green light for folks to come across on a system that is already broken. And it's broken because of us, ladies and gentlemen, Democrats and Republicans. This is not this is a bipartisan issue. We broke it, and we're not willing to fix it because we want our way. But last week I was in El Paso to see what was going on at our southern border, and let me tell you, it was sad, and it was an utter disaster. Last month, Customs and Border Protection apprehended averaged 4,500 people per day. During the first 7 months of the fiscal year, the number of people apprehended surpassed that of any fiscal year total since 2009. And before we go back and try to compare the two, there's not comparison here. 2009 totals were of a different population than we're seeing today that is putting the problem on our system. While I was in El Paso at one point, a single group, while I was there, over 1,100 illegally walked across the border from Juarez into the heart of downtown El Paso, surrendered to Border Patrol agents. I personally witnessed hundreds of others in smaller groups doing the same thing. They already record number of family unit members and unaccompanied alien minors apprehended in April was on track to be surpassed in May. The number of single adult apprehensions has reached a 5-year high. Border Patrol has encountered over 180 large groups, those with over 100 so far this year. Border Patrol processing centers are far beyond capacity. ICE detention centers are full. Even NGOs providing shelter and other aid to migrants are completely overwhelmed. Perhaps the worst part of the flood of aliens coming to the border is the toll it takes on the children brought on the journey. CBP has identified over 3,000 potentially fraudulent family units. Aliens are admitting, this is admitting, that they are borrowing, renting, or bought a child because they knew that if they arrive with a child, they are guaranteed to be admitted. The crisis is real. It is substantial. One of the overworked, overwhelmed agents I talked with last week looked at me and said, "I'm doing my job, you do yours." I took that to heart because I was saying I wanted to help, and he said, "I'm doing my job, you do yours." And he said that I believe this flood of migrants can be substantially stopped by enacting legislation that, along with any other thing we want to deal with, but the Flores fix settlement agreement, which, by the way, President Obama actually appealed as well, to amend the Trafficking Victims Protection Act and to raise the credible fear standard. But I'm not the chairman of this committee, not now, and I don't set the agenda. But we need to do something to address this. However, this bill, just from my humble opinion, is not a help. It fixes an issue that is an itch to scratch, and I don't disagree with that. But it's actually opening up another green light to say, come on, it may take 20 years, but we'll get to you and it'll be okay. Just keep coming. We're not doing that in this bill. My colleagues have the chance to help our overworked men and women of DHS, the overwhelmed NGOs, and the American people who believe in our country's sovereignty. Sadly, my colleagues, the Democrats, are making us consider this bill, which I believe actually worsens it. No doubt at this very minute, smuggling cartels are getting the word out. Congress is going to pass a legalization. You don't believe me? One of my staff members coming back, on the flight that I had from El Paso to Atlanta, a couple of families, which they got here, you could tell they had their manila envelopes that they had gotten from when they came through CBP and went to the NGOs, were on the plane with me to Atlanta. I don't fault them, our system lets them come. But what was the interesting thing that was said? They said, "We're here because we know the president's plan." And what he was talking about was these kind of plans like DACA. The president that I know I can come and I can come across. It's actually there. So it's not just me saying it, it's actually the words of the migrants who are coming in. I have told the chairman and implored the chairman many times, Give us a bill that legalizes some of the illegal immigrant population, that includes enforcement measures to secure our border and enforce our law inside our country. And multiple times I've stated the truth. A bill that grants this kind of legalization, shuns any real enforcement, will be opposed by Republicans because, frankly, it's not working and it's a stunt. And today we're dealing with the same thing. H.R. 6 provides a special path for citizenship for millions of illegal immigrants and hundreds of thousands of temporary protected status and deferred enforced departure recipients. It places the interest of those who have violated our laws before the interest of aliens who have waited patiently for their green cards to become available. Of course, the bill provides some paths to some legal non-immigrants, so the number of potential beneficiaries is completely unknown. The bill allows criminal aliens, those who have committed immigration fraud, to receive a green card. Ultimately, it rewards with a green card and eventual citizenship parents who brought many of these individuals to the U.S. illegally. It incentivizes fraud through lax documentation requirements and the ability to use affidavits to show compliance with those requirements, and through the ability to withdraw an application at any time without prejudice. H.R. 6 purports to prevent alien gang members from eligibility, but the prohibition is so narrowly tailored it's virtually unworkable. We would have adequately addressed these flaws in markup had we considered the bill as it is before us now. Instead, H.R. 6 was split into two bills during the committee consideration, effectively nullifying the opportunity for a full debate at committee level. With those germaneness limitations in mind, I asked the chairman to consider an open rule for H.R. 6. An open rule would allow members to engage in a thorough debate that would have taken place in the Judiciary Committee markup. But also, Mr. Chairman, I'd be remiss if I did not mention the CBO has estimated the two bills combined to make H.R. 6 cost $26.3 billion and $8.3 billion, respectively, from 2020 to 2029. That is $3.46 billion price tag for the American taxpayers. It's not a free lunch. It's not something you can pass off, and it's not something that we can overlook. As evidenced by two floor votes last year, the vast majority of Republicans want to provide legal status for DACA recipients, but they want to do it in the right way, to minimize fraud, to ensure criminals cannot benefit, and to enhance border security. So we won't find ourselves repeating this conversation 5 or 10 or 15 years. H.R. 6 does none of these things, and that is why I'm here, unfortunately, opposing this as we move forward tonight. I yield back.
Well, thank you very much, and I just, I won't be lectured on closed rules by anybody who voted for over 100 closed rules. So
Just a simple smiling reminder, Mr. Chairman.
I appreciate it, but let's all remember why we're here. I mean, we're here basically to help 2.5 million people, many of whom came to the United States as children and who know no other place but this country as their home. Now, CBO estimated the cost of this bill to be $34.6 billion. But what they didn't take into account are the economic benefits of the legislation or the cost of inaction, which is quite costly. A 2017 study by the Center for American Progress found that passage of the DREAM Act alone, not even accounting for the TPS legislation, could increase GDP by as much as $1 trillion. Similarly, research shows that eliminating Dreamers and TPS holders from our workforce would have a detrimental effect on our economy. For example, ending DACA would cost our economy $460 billion in the next decade. And if Salvadoran, Honduran, and Haitian TPS holders were removed from the labor force, the United States would lose $164 billion in GDP over the next 10 years. I mean, these men and women play an important role in our communities, and they are integral parts of our lives. They are hardworking small business owners, teachers, doctors, landscapers, artists, and farmers, and they provide care to our loved ones, and they help build our cities and towns. They pay taxes, they own homes, and purchase goods, all of which contribute to our thriving economy. I would just say that, when we talk about CBO scores, I didn't hear a lot of outrage when the tax bill came up here. By the way, it didn't even go through Ways and Means Committee, and it cost nearly $2 trillion. That's 55 times as much as this legislation. So give me a break, okay? And I just say one other thing, too. We need to deal with the issue of comprehensive immigration, and I don't know what the magic formula is. It's eluded us, and the differences are sharp. But in the meantime, I mean, we have people here, and in the case of TPS recipients, we know that they're law-abiding members of our community. They have to go through background checks every 18 months. The idea that we are going to continue to keep these people in limbo, continue to have them not know whether they have to pack up and leave tomorrow or the next day, while they have families and they have homes, they have businesses here, is cruel. I mean, we can help these people now And yeah, it's going to be difficult to work on comprehensive immigration reform. We've been down that road several times. We need to do it. I'd also say if people are concerned about people coming to our southern border, maybe we ought to have a strategy or a foreign policy that helps stabilize situations in countries like El Salvador and Honduras. The president having a tantrum and basically cutting all assistance to those countries does nothing but increase misery. And misery is one of the reasons why people are leaving. Some of the worst human rights abuses in the world are happening in these countries. So I think we have to do this. I think it's the right thing to do. And I think, we have to show, I think to be true to our own values, to continue to drag our feet on this, I think is unacceptable. Ms. Torres.
Thank you, Chairman, and thank you also to the two members that are here before us to present on this bill. I was really excited coming to D.C., and I'm not often excited coming to D.C., but this week I was, because here again, I see that we have an opportunity to do right by a group of young professionals who have really taken it in the chin when it comes to politics on issues that I think that if we get out of, the political limelight and individually we talk about the issues of dreamers and people under TPS protections, we could agree that these are not concerns to our national security, because these are people that have lived with us, our neighbors, have worked with us, have done everything that they could possibly do to be on the right side of the law, on the right side of our communities, and want to be a part of the American dream. Last week, I met with a group of dreamers from a local community college in my district. These young people were brought here the way I was brought here as a child. Our children don't have a choice. We tell them when to go to bed, when to eat, when they have to go to school, what school that they have to go to. And just like that, their lives and my life was changed. My parents thought it was safer for me to come to the U.S. To live with my father's oldest brother. At the time, Guatemala was a country that was in, the midst of a civil war. 1970 was a very different time in the U.S. I understand that. It was a very different time in the Northern Triangle, too. So, fast forward to now, my trajectory to the U.S. is really not very different than what these young professionals are going through. It is unfortunate, and you're correct, it is unfortunate that Congress hasn't been able to get their act together, that we have allowed outside politics to get in the way of good governance. And you're correct, last year we had a couple of opportunities to bring out bills. One was the Good Lot bill that I highly disagreed with, that I was glad to see defeated in a bipartisan way on the floor. I am happy that it got the opportunity to come to the floor and to have a robust debate on the issue and for us to represent both sides. I found it difficult that at the same time, while we had an opportunity to vote on one bill, Speaker Ryan at the time refused to allow the Democratic bill to come forward, or the bipartisan bill that had been worked out by two members, a Republican and a Democrat, members of our caucuses, and several others had given a lot of input towards that legislation. And it might have been that I did not agree with everything on that bill, but it was a path forward It was a way to get consensus. It was a way for us to get something done without, a bloody fight, debate on the floor. That wasn't an option. So we decided on a discharge petition on the floor. And unfortunately, there again, we were not able to secure all of the signatures that we needed. And we were short one signature, one member of Congress to have the courage to stand up for what is right, one member of Congress to say, we want to have this debate as well as we debated the Good Lot bill. We are representatives of our communities and we deserve to be heard on the floor. That wasn't an option. So I want to tell you about the people that I met with over the weekend. These are young people that they found some safety and a glimmer of hope when, whether you agree with it or not, when President Obama, signed on an executive decision to say, if Congress can't get this done, at the very least, I am going to provide, some safety and security to these group of people. And that's the Dreamers. So these young professionals, one of them, her name is Nydia. She was brought here when she was 6 years old. During that time, not only did she have to take care of herself, she also had to take care of her 3-year-old sister. I can't imagine at 6 years old having to be responsible for yourself or for your sibling, but that's what she had to do. She is now in college, and she is now able to, go to work because she has a work permit. But what happens, when this benefit goes away? What happens when somebody signs off this legal protection that she has? Another DACA recipient filed for a permit. Unfortunately, that permit was delayed. Documents were lost, buried on someone's desk because of the issues that were happening at the time. One moment it was, yes, we support the Dreamers. Another moment, we're not. Another moment, we're taking away that benefit. We're going to court. The court decides they're going to uphold the Obama decision. So that paperwork got lost in the process. She didn't get her permit renewal on time. She lost her job as a result. And for 2 months, she didn't have a job, even though she had to provide as a single mom, for her 2 children. But she managed to make ends meet, regardless, with the help of her family and friends. She made it work. But these are the problems that we're creating in our communities by refusing, to work together, to move forward on a piece of legislation that I think that we all agree. These are not national security concerns. These are people that have been here in our communities. Another constituent was an applied math major at Cal Poly Pomona who was set to graduate last year. And it meant giving up her dreams of a college degree and becoming a researcher. That's how we impacted this young person, and how many more jobs could have been created had she been successful at getting her career and her job. The lack of immigration documents disrupted her ability to stay enrolled in school. So she's been without a job for the last 2 months. Today we have an opportunity to give these young people hope. we have an opportunity to give them the documents that they need and the promise that the American dream is not that far away and that they could still attain it and that they could become, the citizens that we want them, that we are encouraging them to be. So if you came here as a child and you went to college, if you stayed in your job, if you went to the armed services, if you stayed on the right side of the law, we can give them a reliable way to continue to be active participants in our communities through citizenship. This is historic, what we could accomplish here if we are open and allowed ourselves to do more than just play politics. And I hope that we can come to some agreement to do that, because I think that we owe these young children. We don't incarcerate and we don't punish children for the sins of the parents. That's not the society that we are. That I hope that we will stand up for what's right here. And what is right is to move a step forward and continue to incorporate them as the Americans that they are in every way except in paper. So I'm very proud to stand here, with all of you, and I hope that we can move this bill forward. And if not this, what? And if not now, when? And if we don't do it today, and if we don't do it now, and if we don't check this box, there are thousands of people that will continue to be in limbo in our communities. And I think that we deserve to do more than just allow them to stay out there without any real way to create a bigger future for themselves here. With that, I support this bill, and I yield back.
Ms. Torres, thank you for your very thoughtful remarks, and I now will call on the ranking member, Mr. Cole, for 5 minutes.
Thank you very much, Mr. Chairman. If I may, I'd like to submit for the record the statement of administration policy on this legislation.
Without objection.
Thank you very much, Mr. Chairman. I won't read it all, but I think it actually sums up our fundamental problem here with this legislation. That is, the President's making it very clear that unless there's some measure of border security coupled with this, he's not going to sign the bill. And I very seriously doubt the Senate's going to take it up. So we can go through, we seem to enjoy passing things that we know cannot pass in the Senate. We know the President will not sign, and I'm sad to say that's what's going to happen here. To be fair to the President, he said last year there were two different measures brought before the Congress, one which would have extended eventually the right to citizenship. I got 120 some odd Republican votes. I voted for it, was very pleased to do that. Another one that would have given legal status. I would prefer the right path to citizenship, but that got 190-something Republican votes, 193 if I remember correctly. The President said he would sign either one of them, and they would have taken care of the DACA problem. Didn't get a single Democratic vote for either one of those measures. So DACA clearly isn't the be-all and end-all if it's coupled with border security, and I regret that. Ms. Loughran, before I turn to the substance of H.R. 6, I want to briefly discuss a letter that Chairman Nadler sent to Chairman McGovern on Friday, May 31st, and it's a puzzling letter to us on our side. The chairman requested that the Rules Committee grant, quote, an appropriate rule for H.R. 6. And as you know, as generally speaking, when committees send us a bill here, they tell us what kind of rule they want. They have a suggestion. They'll either tell us, Ms. Waters did on H.R. 15, I want a structured rule, or they'll tell us, as Mr. Pallone did recently, I want a closed rule, but they'll give us some indication. And we're not exactly sure where the chairman's at, because I think he's actually submitted an amendment as well. So I suppose that means he is going to be in favor of us having the opportunity to bring amendments on the floor. So let me ask you this, Ms. Loughran, if I may. Do you believe it's appropriate to allow amendment ideas to be discussed and voted on by the full House and with respect to this piece of legislation?
Well, I have not seen the letter from the chairman, and as you know, we were in our districts last week for the Memorial Day celebration or holiday. And I don't know what he had in mind, and I'm here for the bill instead of him. I think it's up to the Rules Committee to decide whether it's a structured rule, a closed rule, or an open rule. You know, I've never served on the Rules Committee, so you're going to have to decide that. We had a very vigorous debate in the committee. We started at 10 in the morning. We went to about 9:30 at night. People weren't cut off. People spoke, and that is, you know, where most of the work on markup bills occur in the committee. So it's up to the Rules Committee what you decide to do.
Well, I'm just asking you your opinion. Do you think we ought to be considering amendments with respect to this legislation?
Well, I've got a list of some of the amendments that were apparently submitted. Some of them I don't think are germane.
I think the chairman's amendment will require a waiver, so.
You know, I don't know. The chairman's amendment isn't on this list, so I don't know about that.
It
Maybe
just arrived.
Mr. Diaz-Balart had proposed an amendment for TPS for Venezuelans. We have a separate bill that we also marked up in the committee that CBO couldn't score in time to be here this evening, so there's no need for that amendment. We've got a bill coming. So, you know, it's up to the committee to decide whether it's necessary. I would like to get this done. As we know, I think half the Congress is going to Normandy and D-Day, and we're out of here on Wednesday, so I'm hoping we can get this done this week.
I share your hope, and I'd like to have gotten something done last year on this, or the year before on this, quite frankly. But we're still in the same situation that you're not going to get a bill through the Senate or signed by the president if there's not some measure of border security here. So, you know, it suggests to me you might get it through the House. I'm sure you will, but it's not going anywhere until there's some larger discussion with the president, with the Senate, about coupling this with border security. Mr. Collins, as I've gone through the bill, it's obviously, as you suggested in your remarks, and Ms. Lofgren suggested in hers, it deals with more than just the DACA population. Could hand out green cards to potentially millions of people beyond that population. So it's a pretty expansive bill, but what I guess what I'm going to ask you is, am I missing something here? Is there a single line in H.R. 6 that addresses the needs of law enforcement or the growing security and humanitarian crisis on the border?
There's not a single line, there's not a single thought, there's not a single possibility here. And that's one of the reasons that I agree with my colleague, Ms. Torres. I mean, this is something that it is hurtful. It is a problem. But when I actually also know, after seeing last week and seeing what is actually coming in here, that this, even inadvertently, could provide another reason to overwhelm, you know, the border without having some of the fixes that we've talked about that curtail, makes this what I've called a perverse incentive to come across the border. This is simply just a problem. I stated some of these, you know, earlier. I mean, we have in April CBP up at 8,800 unaccompanied alien children. This is not just the family unit situation. It's not just the triangle. We had actual African refugees coming through the El Paso border this past week. Again, this is a concern for Mexico as well, because we're having not just the corridor coming through, we're getting from all over the world. The other problem this actually does is my concern with not addressing the security and humanitarian crisis or even giving money here is that we're pulling Border Patrol agents right now off the line to go back and process. They're having to actual process and keep folks in their facilities, which they're not designed to do. That's not what a Border Patrol agent is supposed to be able to do, and they're having to pull this off because they're full, and their processing centers are full. The other issue that I have with this bill, in the discussion of it, is when you look at what's going on here, as how it sort of messes up the rest of the immigration system, which is not talked about here. And this happened, you know, in '86. If we go back to some of these bills that provide a more of a mass legalization issue. In this area, if this bill was passed, we've already talked to the custom enforcement and the folks on how to process this. And if it's all of a sudden at one time to come through the system, is the way I'm understanding this is when we've heard testimony that they're basically going to have to shut down every other part of immigration, that almost everything else of legal immigration will come to a grinding halt to get these processed as the law would require. That means if you've been here for years, you have your paperwork, and you're almost ready, you could get put back because they're going to have to take folks off to deal with this. Now, that's a trade-off but willing to be made. But it's not what we're dealing with here, and when you look at it from a long-term perspective, you're going to continue to have the problem. So you're right, Mr. Cole, this is not getting us closer to where we need to be. Is it where any of us want to be? No. This needs to be fixed. And I think there's enough blame to go around here, but in this bill, this is an issue. You know, it was just to ask, you know, if we're not going to deal with the crisis at the border now, or when, I agree with you. When are we going to deal with it? And I put a bill out there. It may not be the best bill, but we've at least got a bill out there. My unfortunate thought here is much good behind this, as I see. And I will grant you there's not ill will here. I think it's just too expansive. It is good to hear that the chairman of the Rules Committee now is in favor of dynamic scoring. I like that. We're making progress here. But he probably would disagree with me, but that's fine.
Probably not fair to make that when he's not here to defend himself.
I was hoping he'd come back, because I'm going to say, you're in dynamic scoring. We can disagree. I love the chairman. But I think, so this is my problem with it, is there's just too many things missing as we look.
Let me ask you this. Is it fair to say, look, we have a DACA issue because we didn't have adequate border security in the first place?
I think that's
People came into the country illegally. Many cases, those people certainly shown, as my friend from California suggests, they're going to be wonderful citizens of the United States when we give them that opportunity. But, you know, it seems to me you have to have enforcement someplace at the border, or you're just going to continue, as you say, to be a magnet, if you will, to tempt people into breaking the law. Ms. Lofgren, why does this legislation remove the ability of the Department of Homeland Security to consider discretionary factors, things like lengthy arrest records when adjudicating benefits or waivers?
Well, it does not. In fact, it allows the secretary to make a finding that any applicant, even applicants who are otherwise presumably eligible, present a current threat to public safety and deny their application. I wanted, if I could, mention the issue of children coming through the border. Let's not forget that a large number of DACA recipients came with their parents, were brought as children, and overstayed visas. For example, the gentleman who was at our hearing, the Rhodes Scholar, his parents were Korean. They brought him as a child, and you know, now he's a Rhodes Scholar, except he can't go to Oxford because he can't get back in. There's a large number of those individuals as well. I'll just say that a Republican member who will not be mentioned, but who's kind of a friend, so that he was at a town hall meeting talking about the Dreamers, and he gave this analogy. He said, okay, I'm the highway patrol, and you're speeding down the highway. He said, I'm going to ticket you because you're speeding. And I see you got 2 kids in the back seat. I'm going to give them tickets too because they're also speeding. That's not really the way we do things in this country, and we should remedy this if we can.
I agree that we had 2 bills to do exactly that last Congress. Yeah. And nobody on the Democratic side voted for either one.
Well, in my judgment, they didn't do that. As you know, I have spent a lot of time not only practicing immigration law, but teaching immigration law, and I think there were fatal flaws with the structure of those bills. But having said that, for a long time, we've been saying we can't do anything unless we do everything. And finally, we're saying, let's just do something. Let's get something accomplished in this area after nearly 2 decades of spinning our wheels.
I couldn't agree with you more. But you won't get anything accomplished if you don't have some border security coupled with this. It will not pass the Senate. It will not be signed for the president. So if the aim is to pass a bill in the House, gosh, we can do that. But you're not going to get anything else done. And it won't become law. So that's, to me, that's what the fatal flaw is.
Yeah.
Ms. Hoffman, excuse me.
Could I comment on that, and especially, and I consider, you know, a Republican friend, you know, we're friends here, but I think her analysis, her analogy there is flawed in the sense it's not, and even if it was a Republican, given the analogy here, the officer stopping the member for a speeding ticket and then say we're going to give speeding tickets to the ones in the back seat doesn't apply to this bill, because this bill actually says we're not going to give you a speeding ticket. So, you know, you're actually going to have the ability to come in, and it's the expansive opening here. So I think it's a little bit different. I can understand what they're trying to say, but we're also dealing here in a bigger pool of folks.
If the gentleman will yield, all of these Dreamers, except for the court intervention, are removable and deportable the minute the court says, yeah, the president could withdraw. They are subject to, to walking down the street and being arrested, thrown in jail, and being deported. So that's
Yeah,
Your
well-
Republican colleague was making that point.
And I don't disagree, but here's the problem, we're not doing that. And I think that's the issue we have here. And I think going back to one of our colleagues, our former colleagues, who was a Democratic colleague who despised this program and by its own comments, Mr. Gutierrez. I mean, this was when he said this was a terrible idea because you're actually forcing a situation, although it was temporary in its nature, it was a false hope. And now I think if it's done anything to make us talk about it more, then maybe that's the issue. But right now, we've expanded it out, and this is a sad part of where we're at with this.
Yeah. Ms. Lofgren, under H.R. 6, a person who committed fraud or made false claim of U.S. citizenship to the United States government could still be provided a green card. I mean, how does that not further exacerbate the security crisis that already exists on the border and inside our immigration system?
Section 212 A6C, which is applicants are still subject to the underlying Immigration Nationality Act, excludes anyone who by fraud or willful misrepresentation of a material fact seeks to procure a visa or admission to the United States or falsely represents him or herself as a U.S. citizen. However, that misrepresentation must have been made by the alien with respect to the alien's own visa application or application for admission to the United States. Misrepresentations that were made with some other person's visa application for admission wouldn't fall within that. Now, since Dreamers come to the U.S. as children and were not capable of making a misrepresentation in connection with their own application for admission, they would not even be subject to the ground of admissibility. There is a provision in law, and we went through this. Louis Gohmert is a guy who I don't always agree with on the committee, but we had a common cause a number of years ago because there is no waiver for unknowing claim to U.S. citizenship. And so and he had a constituent actually who had a small business who filled out an application for a Texas liquor license. And the guy was a legal permanent resident of the United States. So from what Louis said, they filled out he gave his alien registration number, and then at the bottom he checked a box by mistake that he was a U.S. citizen. Obviously he wasn't representing, he gave his alien number, but this was a false claim, and they deported that guy, and the business, all his employees got laid off and the business closed. So I do think, although we don't go that far, when children are not able to have the full responsibility in contracts or any other area, and that should be part of
But if
this
somebody
provision.
else submitted false information?
Well, I think the interesting issue here, though, and with due respect to Ms. Lofgren, the bill doesn't address 212A6C. In fact, in page 4, it says, it goes through subject to 133D and is not inadmissible under paragraph 1, 6E, 6G, 8, 10. Where's C? It's not there. So that's part of the problem, again.
With the bill.
That we could
could
remedy
fix that with an
with
amendment.
remedy with an open bill, but we can't.
It's, Mr. Collins, my understanding that if an individual committed serious crimes as a juvenile, DHS could still be forced to give them a green card under this legislation, given the way it's written with the mandatory language shall. Is that correct?
Yes, it is correct. And the problem here is the way H.R. 6 is say that they can deny the applicant for the serious issue, but their problem is that because first is how would DHS know of the serious juvenile delinquency adjudication? They're not criminal convictions, and they're juvenile delinquency adjudication, so they don't often appear on rap sheets or anything else for that matter as it comes forward. And H.R. 6 contains no provision that requires the alien to disclose the juvenile delinquency records. Also, the denial provision is so narrowly drafted that it's almost never used. It was written, some provision was so narrowly that only the Secretary of Homeland Security, him or herself, the authority cannot be delegated. Okay, I'm not sure, we had a long conversation about this in committee. I'm not sure what they think the Department of Homeland Security Secretary does, but undoubtedly they just approve waivers all day because we had several times like this. So yeah, it's not there.
You may have answered my question, but let me ask it, and I'll ask it to both of you. Is it true that information contained in federal or state gang databases cannot be used by the Department of Homeland Security to establish gang participation?
No, that's incorrect. It cannot be the deciding factor in determining a violation of the provisions relating to gang activity, which really requires action that models Title 18 activity relating to criminal activity. But it's, the problem is and I've had law enforcement people tell this too, you might have a database that's, 10,000, 50,000 people because of who you hang out with, but it doesn't mean that you're in fact a gang member. You can take that piece of information, but it can't be by itself be used to establish the fact. You have to have clear and convincing evidence that there has been activity defined under Title 18.
Is that the way you read this?
No, it's not. And we had this discussion in committee, and I think this, in page 13 of the bill, it actually goes through evidentiary limitations, and it said for the state, federal, local database, shall not establish. I mean, there's just like, in the discussion in committee was, well, there's errors in this. There's errors in, the no-fly list. There's errors here. But this actually says they can't to establish. The problem you have here is if that is if you were able to look at that and you could see that, whether if it was the only piece of evidence the secretary had, again, we're back to the secretary, he or she making all these decisions by themselves, if that's all they had, that's not enough because you can't establish it. So in other words, if they were in the game database, which if you go to, and Representative Buck from Colorado made a long discussion about this, on how they get there and the parts on this issue, this actually prohibits, if this is the piece of evidence that they're looking at, they can't establish it because it's the only thing they're given. So yes, it does prohibit that from being used. And, and then even the markup memo clearly stated on page 5, it says Section 101C3D prohibits the use of to establish the gang databases to establish gang participation. Yeah. So it's sort of the catch-22. It's a legal circle that in the end will not allow them to do it.
Well, let me, if I may, and I'll make this my last question. Thank you, Mr. Chairman. You've been very generous with the time. I'm going to direct this to you, Mr. Collins. I'm going to ask you if the points I'm making about the HR, or these points are accurate about HR 6. Nothing in this bill is going to be done to address the humanitarian crisis on the border. Which, by the way, we should have done something in that, I would argue, in the disaster bill that we considered today. I mean, I'm going to vote for that bill. But why in the world, when the Information Committee, I had breakfast with Secretary Azar 2 weeks ago, talked by phone with the Deputy Secretary, Mr. Hagan, on Friday. They're running out of money. I mean, they literally need set aside enforcement from it. They're going to have the money to feed people, to house people, give them medical protection, to make sure they're in a safe environment. Nothing in this bill does anything in those areas. My understanding that green cards would be given to those who've already lied to the United States government and potentially committed fraud, not to mention other more serious violent crimes. Our law enforcement would have zero additional resources in this legislation, and those who are here illegally would be treated, frankly, much better than those trying to come to the United States legally and waiting their term to do so. Are those fair points to make?
Those are very fair points.
Okay, thank you. Thank you very much, Mr. Chairman. Madam Chairman, I'm sorry, I didn't see the switch.
Thank you. Ms. Scallon.
So I represent Pennsylvania's 5th District, Philadelphia and surrounding counties, which is a pretty diverse district. The most recent figures I've seen, 10% of my district is foreign-born. People come to Pennsylvania from all over the world, and they have done so since the founding of Pennsylvania by William Penn over 300 years ago. And they've been welcomed, and they are valuable members of our community. Like Ms. Lofgren, I have spent time representing immigrants, DACA applicants and TPS applicants, and folks who come here, although all their stories are a little different, they come here seeking a brighter future, often fleeing unimaginable conditions. And when they get here, they work hard and contribute to our communities. I had the privilege of representing some folks from Haiti, a family from Haiti, just about a year and a half ago, right before I started to run for Congress. This was a family who left Haiti after the 2010 earthquake. The wife was a nurse. The husband, I can't remember what his former occupation was, but they came to the Philadelphia area. He got a job as a sexton for a church. She had to retrain because we didn't recognize her Haitian nursing certificate, but she did retrain. She went through all of the steps necessary to get her nursing license, and they both have worked very hard. They've now had a child in the U.S. So this is a family that has put down roots. They have paid their taxes. They do not collect more benefits than they contribute. In fact, they're barred from collecting most benefits. So these are folks who have contributed to our community, and I look forward to welcoming them as citizens. Ms. Lofgren, we've heard a good deal about the potential for criminal elements to enter using this statute. Is that something that you thought about or that folks thought about when drafting it?
Well, I don't want to speak for the drafters, but as you know, there were significant discussions made on the bills that we marked up in the Judiciary Committee to make sure that we would fully address any concern that might exist about individuals who had criminal convictions. As you're aware, we made sort of a fail-safe provision that the secretary could find that even someone who was presumptively eligible, if the person was a threat to public safety, that they could be disallowed from pursuing the application, which is the ultimate safety net. But we did make sure that the provisions provide for disallowance of various criminal activities. One of the things that's worth keeping in mind is that these are individuals who have basically been here for a very long time. And if you have any felony, you can't, other than an immigration violation, you can't, you're not eligible for this. We wouldn't take someone who's a 25-year-old kid who's lived here all his life as compared to a 25-year-old kid who's lived here since he was 3 months old and say, we're going to oust you, we're going to exile you for a juvenile offense, 10 years ago. I do think we've got the ultimate protection written into the bill, but these are, in fact, de facto Americans.
Yes, Mr. Collins.
And thank you. And I was like, I have a diverse, very agricultural community. I understand what we need to do here. I think the interesting thing here is a couple of points that you had. Is the fail-safe that the gentlelady just talked about is almost like, I don't know if you ever watched Harry Potter. I wanted the invincibility cloak. So I could just throw it on me, walk around, nobody know where I'm at. The problem is it don't exist. You can never get there. And part of this issue is here is this fail-safe is you got to think about how you would ever get there to start with. From the immigration services folks, adjudicators would have to be the ones to start forwarding this up because they found something that they didn't. They're overwhelmed to start with. To actually think that they're going to bring this all the way up to a secretary, who, by the way, has far more than they can handle as just secretary. A fail-safe that isn't really a fail-safe is not a fail-safe. It's something in here to help get it passed. I grant you. And I would put it in there, too, if I was writing the bill from this perspective. The other issue is temporary, the TPS, and you brought some great points on that. But my question, I brought this up in committee. When is TPS? When is the temporary actually there? The ones that are being considered under this bill came under TPS. El Salvador was an earthquake. Haiti was an earthquake. Hurricane Mitch for Honduras. Nepal, an earthquake. Nicaragua, Hurricane Mitch. I'm not going to deny the problems in the countries, but hurricanes, just like the ones who hit America, they do get better, and the people could go home. Because we don't do the temporary. It's just better that the country that they came to, because we don't do it as temporary, we extend it, is now they become their home, not on a temporary basis. The rest, I'll grant you, Somalia, Sudan, Syria, armed conflict. That's a whole different issue. Venezuela, we talked about this in committee, and I said, because we never get to these. I think that's my biggest concern, and should be a concern for all of us. Temporary, these are not temporary. Once they're sort of named, it's so rare. And there are tragic stories here because we let it happen. So again, we're cleaning the slate here, I get it, but that's the concern that future Congresses need to look at. The TPS is not TPS. When hurricanes can cause a 18-year stay, a 9-year stay, a 20-year stay, a 4-year stay, another 20-year stay. When hurricanes or earthquakes can cause that, where's the temporary? It's not there.
If I could, in terms of the TPS provision, you look at some of these countries and it's like, it's one thing after another. I mean, you had Liberia, you had the war, then you had Ebola. I mean, you had Honduras, you had the earthquake, then you had the floods, and you had the landslides, and now you have a situation. It is the most dangerous country, the highest murder rate of any country not at war today. And I raise that because several members have talked about the concern, which I think we all share, about the number of asylees coming to the United States. We are not going to solve a refugee crisis at our borders. We need to go to Central America and look at what is happening in Central America. I have gone, and I know Mr. Collins has gone. I mean, you've got San Salvador has the highest murder rate of any city in the world. And so, you're not, and it's coming down. It was coming down a little bit, but it's unbelievable. So you've got highly dangerous places. It's the basis for TPS, but it's also a problem that we need to work with. It shouldn't just be a U.S. problem. This is something that the nations of the Western Hemisphere ought to be coming together with the UN to deal with this refugee crisis in Central America. And we have urged that happen, and it hasn't happened. And part of what I'm hearing from people in Central America is every day it's some new thing that the administration is tossing out, that they're going to make it harder, they're going to do this, they're going to eliminate the standards. And so there's a sense of panic that people, if they're going to get out, they need to get out now, and it's actually increasing, the threats are increasing the level of departures from those Central American countries. It's really a very serious problem.
It's your time, can I respond? Because I think this is a good discussion, and it's an honest discussion. But I think what the gentlelady just said was made my point. There is no such thing as temporary here. I could go to, out of however many countries in the world, to use the standards she used. We just ought to have every country in Africa, almost every country in Africa, almost many countries in Southeast Asia, others would fall under that category. And something happens all the time. It's like parenting. Something's going to happen all the time. I'm in the reserves, and I always told the reservists, the reserve weekend is when everything's going to fall apart at the house. The dog's going to die, the back's going to flood. It's all going to happen on reserve weekends. That's exactly what happened. That's why this is not temporary. I agree we need to find a way. I don't disagree also that asylum is not going to be cured. But remember, let's go back to President Obama when we had the first, what we called crisis here. That was not under an administration who, said the thing. This was under a different, because our laws keep this happening. We need to work with our countries in Central America. I don't deny that. We need to. As someone who's fought in wars, I don't think that foreign policy and State Department and foreign aid works. You're not locking somebody who doesn't. But when you have the perverse incentive that says, you get here, you're fine. One last example. Right now in El Paso, there are almost 1,500 Cubans who have came on asylum. I don't think there's anybody in this room that believes they're not going to be eventually, because credible fear for them is real. Because what one of them told me, if I go back, here's what happens. They disappear me. Mm-hmm. Nobody in this room is going to say that. You know what? They're there for upwards of 90 days, and they're seeing unaccompanied minors and family units, some fraudulent, are there less than 24 to 72 hours. If there's not an emergency now, when's there an emergency? You bring up great points. I just don't think this bill is solving what we're wanting to solve and actually gives another incentive on top of this.
Just a correction that TPS is only for people who are already here. It's not for new entrants.
It doesn't extend to the others.
Correct.
And that is very much the concern I have, just based on the folks I've been dealing with, and certainly the many amazing stories of the DACA kids who are now the DACA medical students and law students and social workers and teachers, and with that, I'll yield back.
One quick thing, though, and I apologize, Madam Chair, because it doesn't apply just to those that are here. If they've gone back, they could still apply. So if they could have been here and they went back, they could still come back. So it doesn't just say that they stayed here. If they've gone back, they can still apply under this. So it's not just simply those that are here.
And the gentlewoman yields back. Mr. Woodall.
Thank you, Madam Chair. I'd like to pick up where Mr. Collins just left off, because I don't want to gentleman's from my home state. He's in a neighboring district. Almost everything he says is gospel, but I'm reading I'm reading the dissenting views in the committee report, and I have some questions. It says that aliens outside of the United States today who received TPS formerly under designations that President Obama terminated in 2017 would be eligible for status under this proposal. That's right. Aliens for whom temporary protected status no longer exists, who have left the United States of America and gone home, would now be eligible for a permanent status to come immediately back to the United States.
I don't think that's accurate. It's only if people left after January 1st, 2017, and it's at the discretion of the secretary, so it's not a right.
Well, but left because their status had been canceled, right? There was no TPS status
Correct.
for them, and so they left.
And it's a recognition that errors were made, and it's not a right. The secretary has the discretion to allow that. Say, for example, let's do a what if, I'll make it up. You lost your TPS protection and you went back to Syria. And Syria is not a safe place to be, and you hope to regain your TPS status. The secretary would have, on a discretionary basis, the capacity to allow that.
But for these areas where TPS no longer exists, right?
That's also true of Syria.
You use Syria as a dangerous place. Is there TPS status for Syrians today?
No. Well, it's like the other TPS statuses that have been removed, and the courts have stepped in to do temporary halt on that removal.
Yep, extended Syria.
Well, then my off the top of my head example was not a good one. We'll go to Somalia or Sudan. All I'm saying is there are times when someone's protection was removed. Rather than go underground, they complied, and yet they could be at serious risk. It gives the opportunity for the secretary to respond, but not the requirement.
But it's not outside the United States, back in your home dangerous country. If you've left the United States and you're now summering in London, you're still eligible for this protection.
Well, then the secretary, I'm sure, would not approve it. The point is, you've had people who've lived here for a long time, who had ties here. I've met, I'm sure you have too, people, let's use the Liberians as an example. I mean, what an incredibly talented group of individuals who I've met, in the medical profession and in accounting and academia, and they've been here for 20 years. They're married, they have kids, they have grandkids, they have businesses and homes. So it's not as if there's no tie to the United States. And in many cases, the ties are stronger to the United States while they were legally present than it is to the country that they were originally from.
Well,
Mr.
Collins?
I just wanted to interject. The gentlelady just she answered exactly the way I would. She's correct. She answered it correctly. Yes, they can. And she's saying it's because of mistakes, and that's fine, but this bill does have that. And I think, to keep going back, a concern that I have here is we keep going back to the secretary. I want the secretary to come to an oversight hearing because I want to know what their time looks like. Because undoubtedly, if they have all the time in the world to take individual reports and do these all the time, then I'm missing it somewhere.
Well, and to your point about how to deal with convictions and records, that's what the chairman's amendment was, if you've not seen it yet. He was saying that we defined conviction as the committee reported the bill incorrectly and wanted to expand it to conviction and adjudication. And those kinds of things we would be able to fix on the floor of the House if we had a rule that allowed that. Ms. Scanlon mentioned 10% of her district is foreign-born. More than a quarter of my district is foreign-born, which means, and the reason I ask about folks who are outside the country, Ms. Lofgren, is that if you're the married child of a U.S. citizen today, you've been standing in line for almost 13 years waiting on your number to
correct.
come up. And you talk about an incredibly talented group of people. I've got those constituents with those stories. When you said that let's just do something, let's do something that has bipartisan consensus, I would have guessed that doing something for American citizens who were being burdened by the immigration process today would have been the place we would have started. Is it because I trust your judgment, and I've always enjoyed you as a witness in the committee as well as a partner on the floor, is this really the most bipartisan come-together consensus issue that we can work on to just get something done to help get this ball rolling?
If I may, it is one thing that needs doing, but if you are interested in working with me in helping the adult married sons and daughters of American citizens, I'm going to find you, and we'll look and see if we can't do a solution for that, because you're right, that is a terrible
Well,
problem.
spouses of American citizens, right? We've got all
Well,
this.
spouses of American citizens are immediate relatives, and they're not subject to the cap. But we do have a problem because of the 3 and 10-year bar
Well,
that
you
was
make-
put
you
into
make
the act
exactly my
in
point.
1996. And as you are probably aware, I've been talking to Republicans to see if we can't come up with a bipartisan fix for that. I've had a lot of nodding heads, but nobody signing on the line yet. So let's talk further.
Well, I would love to talk about.
All right.
I'd love to talk about that. Mr. Collins?
Well, I think one of the issues here, and it came up earlier in talking about amendments and why this, again, should be debated on the floor, is the amendment from Mr. Nadler and also Mr. Cardenas and Ms. Garcia of Illinois was an interesting line. It says, page 16, line 8, strike the term convicted or conviction and insert term convicted, conviction, or adjudicator, adjudication in this page 16 line. What it basically does, and this is interesting, the bill already makes DHS ignore expunged adult criminal convictions or rehabilitative sentences. What this amendment would do the same for juvenile. So what we're just, again, something that was worked out in committee. I'm not saying if you like the bill, this would probably be a good amendment to put in, but it also shows why this is still a work in progress going forward, and also why it does, as I think Mr. Cole had asked, how these convictions are ignored in this, going back to that famous fail-safe that we've looked at.
Well, the chairman said in his opening comments, we're talking about folks who came to the U.S. as children and know no other place than this as their home. Ms. Lofgren said in her opening comments, we're talking about folks who came to the U.S. as children and are American in every way. Mr. Peterson, a Democrat from Minnesota, has an amendment that would help all of my constituents who are H-1B holders, whose children have been here since day one, who know no other country than the United States as their own, who do not speak the tongues of the dialects of their native homes, and for whom their parents have done everything right, played by the rule in every respect. They are children just like the DACA children, and in my reading of this bill, I see absolutely no relief for them whatsoever, though, again, I think the amendment Mr. Peterson offers would solve that. Can you tell me, Ms. Lofgren, why in the world this seemingly a sympathetic population, again, children just like the ones you described, the only thing that distinguishes them is their parents did everything right instead of their parents doing something wrong?
There is a need for a remedy for other parts of the Immigration and Nationality Act, and you have identified some, and you've now identified yourself as someone I'm going to hunt down to be a partner on fixing some of this.
You don't have to hunt me down. I've had my name on the Yoder bill for as long as I've been in Congress.
We're hoping, that's now the Lofgren bill. We've made some changes. It was originally the Lofgren bill before the gentleman from Utah expropriated it, and then Mr. Yoder inherited it, and it has now come back to the original author. But in any case, we now have over 290 co-sponsors of that bill. So I'm hoping that we will be able to move that without coming to the Rules Committee and get that done, because that's a super majority.
You're making it even more confusing to me. This is your language on an issue that 2/3 of the House has at one time co-sponsored. It is exactly the kind of consensus issue, let's get something done together, and yet we arrive in the Rules Committee today cobbling together different bills into one, and the consensus language that you represent is nowhere to be found.
Well, if I may, on this, I've been working on immigration reform for quite some time, and we've never accomplished anything. Nothing, zip. And because the problem has been, as soon as you do one thing, then, well, we can't do that unless we also do X and Y. And if you do X and Y, then you have to do A and B. And then there's L and D, and pretty soon you've got a bill, and then you've got, and we can't move it forward. So we're trying a different approach this year. We're going to do the DREAM Act and the TPS. Then we're hoping to move the bill on the per country. We've got a couple other things in the works. We're pulling together a bipartisan group to work on ag labor reform that we hope will be very suitable for the broad House. And if we can get, and the 3 and 10 year bar issue, that we're trying to build separate approaches to very real problems rather than saying, well, we can't do anything because we are not doing
Well,
everything.
put me in the camp of folks who say we shouldn't be doing something for families who have done it wrong while ignoring families who are in the exact same limbo, facing the exact same deportation challenges in many cases, and they've done everything right along the way. I just don't understand. Again, 290 of us agree with the approach that you've taken, and yet that sits silently on the sidelines. A divisive issue like this heads to the floor, and then a destination of nowhere. Mr. Collins?
But one of the things, though, and I agree with what the gentlelady said on the principles of things that we can do, but what I disagree with is I heard nothing in there that just frankly just broke my heart. When I looked at Border Patrol agents last week who looked at me and said, we're doing our job, you do yours, and nothing that she just laid out in the agenda coming ahead has anything to do with the gate that is left wide open and the encouragement to come here, I'm agreeing with you. I'm agreeing we need ag guest worker. I'm agreeing we need to do these things that we've just talked about in ways that can come bipartisan. But when, and I know, I'm hoping she just left it out because we're talking about things that we could do. But this is my problem with this bill.
Well, if the gentleman
We
would
don't.
yield, since he's referred to my comments, I was responding to
And I
Mr.
agree.
Woodall's questions about other elements of
But with the-
immigration reform in the Immigration and Nationality Act, which is not the border security issues that the gentleman has referred to.
And I hope the gentlelady would join me in finding a solution to that. We put a bill out there. So let's try to find one, because right now, it ain't there, and they're still coming. And this will do nothing but help the green light.
As the ranking member said, this bill is not going anywhere beyond this chamber, and that does not help any of the people that we have all identified an interest in serving. But I will tell you with great sincerity, I know the gentleman from Georgia is a serious legislator and has been known to take risks that get his backside chewed on a regular basis. And I know the gentlelady has also been known to go down that very same road. So if anybody can get us to something that really is that consensus issue that breaks the gridlock that has been facing us since the 1990s, I would be grateful to you both for doing it. I yield back.
Gentleman yields back. Sounds like both the gentleman from Georgia would like to co-sponsor something, and we'll see what that is. I'm going to recognize now Mr. Morelli.
Thank you, Mr. Chairman. And I thank the chair and the ranking member for being here. I represent upstate New York, where we have migrant farm workers, but obviously, in terms of the immigration issue, we're on the northern border. But I just wanted to make a couple of perhaps general comments, if I might. And I'm prompted to say this because I have enormous respect for Mr. Cole, and I heard what he said as it relates to the idea that this is a bill that perhaps won't get passed in the Senate and won't make its way to the White House. And it raises a larger issue, sort of broadly speaking, in my mind, around the questions of both the border security, which you're obviously interested in, as well as the path to citizenship, which in my mind is literally part of our national DNA. Virtually everyone here came here from somewhere else, some voluntarily, some involuntarily, but this is a part of what has made America so extraordinary. And I think of my family, which was not here during the Revolutionary War, wasn't here during the Civil War, came in the early 20th century. There was virtually no test for my family. thankfully, because I'm not sure they would have all made it. But the test at Ellis Island in New York was essentially, were you healthy enough to come into the United States? So did you have smallpox? Did you have whooping cough? Otherwise, you essentially, that was about the ticket to get in. We came in by the hundreds of thousands and millions. So not only is it part of our national DNA, though, but I think of it in terms of where we are just from self-interested point of view, in terms of the national interest, a decline in workforce rates, decline in birth rates. We have a great need for people coming into this country. But right now, I don't see any desire on the part, frankly, of the leader of the country to do anything other than demonize people. And I find that very frustrating. I agree. I think we should be talking about a comprehensive solution, path to citizenship, securing our borders, making sure that we can all come together in a bipartisan way, despite whatever differences we have. But where do we, what's this debate been about? First of all, a promise that we were going to build a wall paid for by the Mexican government, the Mexican people. That didn't work. Family separation policy, a government shutdown over this. And the latest thing is a tariff, 5%, 10%, 15%, 20%, 25%. If somehow we don't stop the inflow of people coming from Central America to flee some of the worst conditions you could ever find anywhere in the world, and that's been talked about here. So I agree with Mr. Cole. As I said, I have enormous respect for him. But in my view, this is a national leadership issue. Let's not demonize people. Let's sit down. There's a lot of very smart people here in both houses that will work with the administration. But I'll support this bill because I think it's the right thing to do. But I agree that we should have a broader question. I'd really appreciate if the occupant in the White House didn't make this such a wedge issue and try to divide people and further polarize a country that needs more healing than it needs divisiveness. Thank you.
Mr. Burgess.
Thank you. Just a couple of things. Mr. Collins, thank you for mentioning the fact that not all of the people coming across at the southern border originate in Mexico and Central America. I had, for the record, a Washington Post article detailing Congo refugees that are showing up and spending time in Mexico waiting to come to this country. Also, here's a Politico article from December of 2010 talking about, of course, we didn't have deferred action for childhood arrival. We did have the DREAM Act. And it's just interesting because the history of this, in 2010, of course, there were 59 Democratic senators and 41 Republican senators. And the DREAM Act, which passed the House, didn't pass until December of 2010, so it was in the lame duck session before the Congress ended that year. But when it got over to the Senate, the House did pass it. When it got over to the Senate, 5 Democrats voted against the legislation. Kay Hagan, Mark Pryor, Ben Nelson, John Tester, Max Baucus. Joe Manchin did not vote that day, but said he would have voted against it had he been here. 3 Republicans crossed party lines to vote for the bill: Richard Lugar, Lisa Murkowski, and Utah Senator Bob Bennett. So had all Democrats voted for the bill in December of 2010, there would have been enough votes to break the filibuster, and presumably it would have passed on the floor. So again, I'd ask unanimous consent to add this as part of a record
Without
of our
objection.
proceedings today. And Mr. Collins, thank you for going to El Paso last week. I also went to the southern border. I went to McAllen, Texas last week. I suspect the same things you saw. I saw Customs and Border Patrol that were overwhelmed, that were not just asking for help, but beseeching the Congress for help. I suspect you heard some of the same things I heard as far as the need for reforming asylum laws, and that couldn't have been more clear to me as I made that visit last week. But one of the things that just really strikes me is that now the bill we have before us today, the recipient of a deferred action for childhood arrival has to have been in this country for 4 years. Do I understand that correctly? So, doing the quick math on that, children that arrived in 2014 and 2015, when this current surge of unaccompanied alien children started, 2014, 2015, they actually would be now eligible for a DACA status. Is that correct? And yet, Mr. Collins, again, I'm sure you saw the same things I saw down in the McAllen station. Significant numbers, yes, young adults, yes, young men and women, but children who were, they're going to be placed somewhere, probably in an ORR, Office of Refugee Resettlement Facility, but they will be placed somewhere. So if they wait for 4 years, are they going to be eligible to apply for this new status as well? In other words, are we just continuing to fuel that pipeline and draw more people into that pipeline in a way that really, it's almost inhumane what we're asking them to go through to get here? So, Mr. Collins, is that your understanding?
I think the problem that you have here is understanding, I agree with you completely, is we're setting up another green light here. And just to simply say more come over, and whether it be the TPS side of this, whether it be the DACA, Dreamer, whatever, however population we want to call it, is you're setting up just another, pathway to say that when you get here, just get here. And that's the concern that we have here. And again, this has been growing. It's a concern. I don't mind having the discussion about the DACA population. In fact, I would want to do a bill, but we can't keep doing what we're doing on the border and expecting the men and women of our Border Patrol and Customs Enforcement, our port authorities, to continue to do this in any way that would actually give incentive for more people to come across. When you see, as you saw, as I saw, you saw, a 20-year-old with a 3-year-old who came, up through, from the Central America and coming up through here. I don't fault wanting to come, but, also the interesting thing is, and it was mentioned just a few moments ago, and I appreciate the fact that there was, that just as long as you didn't have disease, that you could come into the country. Well, they get to our border right now, and we're seeing everything in the world from scabies to scarlet fever to measles to mumps to H1N1 flu, everything, and they're being taken care of. That's something else I want to say tonight. No matter how you vote on this bill, I would prefer that no one in this body ever denigrate our Customs, Border Patrol agents, and our Port Entry, our ICE people, for doing their job. And I think that's one of the things that it broke my heart the other night just to see not only the situation we're helping here by continuing this kind of a process, but also putting them in positions that they're just untenable with. So I see it, and I agree with you from that perspective.
Well, in 2014, when this crisis hit the headlines and I started visiting our facilities down on the border, and I will tell you, back in 2014, there wasn't much done in the way of screening. And I think, Mr. Collins, you're exactly right. There is a lot that occurs in the way of screening now.
And they're getting medical treatment. That's the biggest thing.
And that is exactly right. And in fact, I think it was some of the work of our committee, the Committee of Oversight and Investigations and the Energy and Commerce Committee, that required there wasn't even a doctor who worked for the agency at that point, and that was instituted back in May of 2014. So, Mr. McGovern referenced a small number. Do we know what the number is? Do we have a good handle on what the number of people that we're talking about that would be covered under this bill that's before us today?
I think the numbers that I repeated earlier today in my opening is basically, if you're using the population, 2.1 to 3.7 million under the Dreamer part of this, 500,000 under the DED, and then really TPS is unknown.
So unknown.
Yeah, because of the way it's worded, and we've went through that. I mean, but there's just unknown. It's just or eligible for it.
So we're
the unknown eligibility.
We're granting a permanent resident status to an unknown number of people
The gentleman
and
yield?
doing nothing, my time if I could, and doing nothing to disincentivize future arrivals. Is that correct, Mr. Collins?
There's no, I mean, this, in my opinion, look, no matter what this does, it does provide another incentive for people to come across, because at some point they'll say, we'll bid here, and as long as we get here, it'll be fine.
And we don't know how big the number is right now.
From the future, that's unpredictable.
But we don't know the right now,
Yeah,
the
I mean,
right now
that-
number.
The TPS issue is the one that's in debate. And because that's the none, because you have eligible and you have those that could, and how they could apply, so. Sorry. TPS recipients are set, but TPS eligible under this is the unset,
Right, yeah.
is the unset number. So TPS, yeah, and that's,
Yeah,
I agree with the
okay.
chairman on that.
Yeah, thank you.
We've been talking about.
He
this for a
agrees with
while.
me, so I just said thank you.
Yeah.
Agreed with you.
Yeah, and he was, and it was probably, we've been talking about this for a long time, and it's the eligible and then in the TPS, the recipients. So the recipients are known, the eligible is an open-ended.
Let me ask you this. Is there a plan in this bill to provide the resources that will be needed by Customs and Border Patrol, Immigration Customs Enforcement, Office of Refugee Resettlement to deal with this influx?
No, that has been painfully brought out in this committee. And then the part that's also not been discussed tonight is what I brought up earlier, is the effect on the processing of these. If this bill became today, the CIS they would not be able to process it. They just put everything else on hold just to process this. And this is exactly what we saw back in '86. So that got put behind. And that's just a byproduct of this, but it just needs to be understood as well.
So too, it's important to point out that currently, someone is picked up, particularly in a case of a child, picked up by Customs and Border Patrol. They can be held at a processing facility at the Border Patrol station for 72 hours, at which time by law they are supposed to be transferred to the care of Department of Health and Human Services, the Office of Refugee Resettlement. The problem is, the Office of Refugee Resettlement is now completely full, and so there is no place to put the child who is picked up by Customs and Border Patrol. So some are having to stay in a processing facility for longer than that 72-hour maximum.
Yes.
And that's exactly what I saw in McAllen.
Exactly right.
And one of the reasons I selected McAllen to go to was because I'd heard the week before that they were under a quarantine from H1N1. When I got down there, it turns out they weren't under a quarantine, but they'd had a significant number of illness. And again, these are not kids who got sick after they arrived. These are kids who arrived who were ill and having to be taken care of by our personnel and Customs and Border Patrol. Well, Mr. Collins, you're on the committee. You had the markups in committee. You had the hearings in committee. Do you think that this is going to help or exacerbate our border crisis?
I think the end result is that it will continue the process of encouraging while not fixing a problem. Even if this went through the Senate, went through that, this will actually, in my mind, actually just give another green light, because as long as you don't have the incentive not to come, or incentive to know that you can just get here and get in without, any prerequisite or anything else, it just is an incentive to be here. And you can argue the merits or dismerits of the bill itself, but we have seen that, and we're hearing reports from the Central American countries or other countries around the world that they are saying that now is the time. And the one part I agree with the gentlelady from California on is that they do hear what we have going on, and they understand what our laws are. And the gentlelady made the comment that they fear the window is closing. That should tell us all something here. If they fear the window is closing, then they know that we have a problem here on the border. Whether we agree or disagree on how to fix it, if the window is closing, then there is a problem. And if that's the way the world views our borders, that's a problem.
Well, if since the gentleman
and
referred to me, the president,
Language.
and very polite language, the president has threatened to close the border and various other things. And, if the gangs are coming, it was described to me in Honduras and El Salvador that the situation in certain parts of that country is not that different than ISIS. They said it's like ISIS without religion. That's how dire it is. And the question is, how do you get out? When do you get out? And it's, if the president's going to close the border, you don't, maybe you need to walk instead of, it's making people frantic was what I meant to say. Mr. Collins. I know we have a vote on. I don't know what the
Yeah.
protocol is for the Rules Committee with votes, but
We talk until we can't.
I say,
Can I comment on it? 'Cause, yeah, up here we
I
just
keep
talk-
saying, where's the 5-minute rule in the
Well,
Rules
yeah, I know,
Committee?
we should, that should have been in our rules reform package.
Where's Virginia Fox when we need her? You know, but if the gentleman will allow, and this is, again, goes back, let's just, again, sometimes we get into administrations. I agree that my other side is there's a discussion on this administration. We've heard it come up several times now. But remember, when you and I here, we stayed an extra week in July because there was a crisis at our border by President Obama. And that we would put this money, we stayed and passed money so that this could be a fix. The numbers now are heavier and larger than they were then, but yet we cannot get a vote on the floor for the package of aid that has been asked for. In fact, it was actually voted down on the floor. It was bigger problem now than it was then. And what was interesting is the gentlelady talked about is we also gave money into those Central American countries to help this, and the flows continued and have now gotten worse. So it's not just a matter of somebody saying the border is going to be closed. It's a matter of nothing has worked at this point because the incentive is still there. The Obama administration even said the Flores decision was a bad one. They appealed that decision because they knew it was unworkable. So that's when the catch and release process basically became, because they knew they couldn't work it. They appealed it, but it was not overturned. So these are just issues that we have, and that's why I believe, and why we differ here, is that this is an incentive, again. Whether it's dealing with it specifically or not, it just opens up another green light.
I do agree with you that our words do matter, and people do hear our words, not just in this country, but in other countries. In 2014, I was at Lackland Air Force Base around the same time that Ana Hernandez, the First Lady of Honduras, was there. And she was asked, do you want your children back? And she said, yes, we want our children back. And so for a brief period of time, they put kids on planes and sent them back to Honduras. And that did have the effect of significantly lowering the pressure. I think that phenomenon has been demonstrated several times. I do remember back in 1993 or 1992, when Bill Clinton was running against George Herbert Walker Bush for President of the United States. And George Herbert Walker Bush was faced with the prospect of Haitians coming over to this country by boat, and he would intercept them at the high seas, hold them in Guantanamo for a short period of time, and then repatriate them back in Haiti. And Bill Clinton said, this is just untenable. This is not who we are as a country. It's like we put the closed sign on the Statue of Liberty or no vacancy sign on the door. And by golly, when I'm president, this will be different. And then, of course, Bill Clinton was elected. But shortly before he took office, he was required to give an address through Voice of America telling Haitians not to build boats and come to this country because it was estimated there were between 400,000 and 800,000 people that we're going to take to the dangerous waters in the Straits of Florida in homemade boats to get to this country. Our words really do matter when they are heard in other areas. You know, I do want, and I will wrap up with this. We talked a little bit about the CBO report. Just for fun, I went back and looked up the CBO report for HR 7311. Signed by the President December 23rd, 2008. This was the Trafficking Victims Protection Reauthorization Act. What gave us the asylum loophole that is now probably front and center in our crisis here. But the Congressional Budget Office, when it looked at this bill as presented, as passed by the Congress and presented to the President, said it would reduce the deficit by $2 billion over 10 years. I offer that just for the point that when we see a Congressional Budget Office estimate, there is no way to know what the downstream effects are going to be. So the Wilberforce Trafficking and Victims of Protection Reauthorization Act was supposed to reduce the deficit by $2 billion. What do you think we've spent, Mr. Collins, since that emergency supplemental that President Obama asked for when we had to stay here prior to the August recess a few years ago?
At this late hour, my math is bad, so if you have the answer, go right ahead.
It's a lot.
I'm sure it'll be a lot.
It's a lot, and it was a lot more than $2 billion in deficit reduction.
And also, just to take the moment while the chairman is back, I did make a comment you had mentioned earlier about the not taking into account stuff on scoring, and I made the comment, and I wanted to make it with you here, that I was glad to see you now agree with us on dynamic scoring, so, for the bills, I appreciate it. It's good to see you back.
We're thrilled to be back.
Yeah,
Are you done?
Yeah, I'll yield back, Mr. Chair.
Okay, so here's the deal. We've got about 4 minutes before we have to go. Does anyone here have any questions on this side before I? If you feel you have to ask. Well, the question is, we would have to force these guys to come back if we go over. Okay. Ms. Lesko, you got 4 minutes we can give to you to, unless you want them to come back. Sure.
Mr. Chair, I think we've revealed all the questions that were primarily on my mind already, but I do want to confirm that in your opening statement, I think you said something about that this would help a small group focused on DACA recipients, and I respectfully disagree, because what I read, it says that to be eligible for DACA, this was under the Obama executive order, an individual had to prove they entered the U.S. before the age of 16, and you had to be under 31 at the age on June 15, 2012. This would change it to anyone under 18, and also there's no upper limit. So we're talking about millions and millions of more people. This is a great expansion. But I have some amendments, and I will get to that later.
We will come back. I think there are questions on this side, too. Michelle.
Back for statements? Are we coming back for amendments?
We have a little time. The questions of this panel. Oh, Mr. Raskin, did you have a question for this panel? I'm fine with this panel. If I can make a statement. Oh, yeah, no, everybody, we're all coming back. The question is whether these guys had to come back. All right. All right. So, without objection, the committee stands at recess, subject to the call of the chair. I would ask members to return at the start of the last vote, and then we could go to your statements, and Ms. Lesko, Mr. Burgess want to testify, so we will have plenty of time then. We are now back in to talk about H.R. 6. And before I yield to Ms. Shalala for some comments, I want to ask unanimous consent to insert in the record statement by the Honorable Gregorio Sablan and Congressman Buddy Carter. Without objection, they will be entered into the record. I know some people have some comments and statements they want to make, and I will yield now to the gentlewoman from Florida, Ms. Shalala.
Thank you very much, Mr. Chairman. More than half of the people in my district were not born in the United States, and I couldn't be more enthusiastic about what I consider a pretty narrow bill that covered the Dreamers, TPS holders, and DED recipients. These immigrants and their families are really part of our lives, and they probably have served the longest probationary period in American history for permanent status in this country. Many of them were students of mine at the University of Miami. They were my colleagues. They were our graduates. They're my friends and my neighbors. And they deserve an opportunity for permanent status. They've done nothing wrong. So many of these young people came here when they were really young. I know a world-class runner that could not go to Europe to run. She came here as a 2-year-old. All of her sisters and brothers were born in this country. Her parents became citizens. They simply didn't know that they should apply for citizenship for her. And as a result, she had to change her plans. There are so many tragic stories of these DACA recipients, but today ought to be a day, and tomorrow, when we have an opportunity to vote on this bill, is again making this country a land of opportunity. So I'm very pleased that I'll be able to go home to my community and celebrate another chapter in American history to give people who have lived as good citizens an opportunity for permanent residency. Thank you.
Well, thank you very much. And I know Mr. Raskin wanted to.
Mr. Chairman, thank you very much. Thank you for your leadership on this. I'm delighted to follow Congresswoman Shalala, who has been such a great leader for the people of her district. And in my district over the weekend, I met some people who had gone to school at the University of Miami under her leadership and felt that she was such a shining beacon for the students there and for a lot of the immigrant students who go to school down there. So you continue to do great work, Congresswoman Shalala. And I'm delighted to add my voice to the chorus of praise for the DREAM Act and the Promise Act. In my district, we have thousands of people. In Maryland, we have 38,000 Dreamers. We have 30,000 people who are here under the TPS DED categories. This could obviously not be of any greater importance or urgency to these people who've been twisting in the wind for many years now. These are people who live in our communities. They go to school, they go to college here, they work in our communities, they contribute to our economy. They work as elementary school teachers, as bricklayers, as farm workers, doctors. They serve in every branch of the military. They're really part of America. One young man I know, because I coached him on our kids' soccer team, the Orange team, growing up. I didn't realize when he was on the team that he was not a U.S. citizen. He went to school here, as the Supreme Court has ordered is the right of the children of undocumented parents. He graduated from high school here. He went to community college here, and he's been working as a paramedic and as a painter. And he's just waiting to get along with his life, Mr. Chairman. My office has also collected stories of people who come to talk to us. Here's one of a woman who is named Xiomara Cruz, and she came to the U.S. in December of 2000 with her 2 sons, William, who was 7, and Edwin, who was 3, to visit their family. They had family who lived here. grandmother, aunts, and cousins who all lived in Maryland, and they made frequent trips here, and they would go back to El Salvador. And Xiomara was studying medicine there to become a nurse or a doctor. And while they were here on January 13th, and then again on February 13th, 2001, El Salvador was rocked by these two massive earthquakes, followed, you may recall, by these terrifying aftershocks. Thousands of people were instantly killed, injured, or missing. So many houses were destroyed that 1.3 million people in El Salvador were displaced out of a total population of 6.2 million. And when the U.S. government offered the temporary protective status to Salvadorans in March of that year, Xiomara's family convinced her to apply and to stay in the U.S., and she did, and raised the boys here. She created her own house cleaning business with her own website. Within 1 year, she began to employ other women to keep up with the demand, and the boys would come along and help when they weren't in school, and she ended up employing lots of other people to work in her business. She eventually bought a house. She sold a house, and she bought another one in a better school district for her kids. She said to us, "I had such a thirst for work. My sisters thought that it couldn't last, but I just kept going and kept going." She paid her taxes faithfully, understanding that that was part of the contract, essentially, for staying in the United States, even though she was not earning Social Security credits or anything like that. But she said, and her kids feel the same way, that she feels every bit as American as her sister and her families. Every 18 months for 17 years, she paid the required fees to the government to renew their TPS status. They want to stay and become part of the story that is America. And El Salvador is a country that continues to be riven with terrible crime and conflict. And Mr. Chairman, I had a visit a couple weeks ago from people in the hotel industry in Maryland, from a lot of the big hotels and a lot of the small hotels, and they all told me the same thing, which is they are suffering from terrible labor shortages. They cannot find people to come and work at the most entry levels in those hotels, whether it's restaurant, desk, cleaning jobs, what have you. I'm hearing the same thing from people in the construction industry, that they are suffering from terrible labor shortages. All across the land, there are industries, the seafood industry in Maryland, retail, where there simply aren't enough workers. And now we've got people who've been living in our country for many years, who identify with our country, whose kids grew up here, who are in school here, who are working here, or serving us in the military. And we've got the opportunity with this legislation to make them whole, to give them a pathway to citizenship. So I'm very proud of where we are. I hope that we pass it overwhelmingly in the House, and I hope that the Senate will actually do its duty and bring it up and vote on it so these people can get on with their lives. And I'm with Mr. Cole that we need to move then to comprehensive immigration reform. It's clearly what we've been crying out for, and everybody should be able to agree to it. But in the meantime, we should not leave these people on hold any longer to twist in the wind. And I yield back to you, Mr. Chairman.
Thank you very much. I know Mr. Burgess and Ms. Lesko have amendments that they want to testify on, so I'll yield to Mr. Burgess.
Thank you, Mr. Chairman. I have an amendment to the rule, amendment number 16.
No, we're just taking your testimony.
Oh, testimony.
Or do you want to give testimony, or do you just want?
No, I'm happy to give testimony.
Okay.
This amendment makes a DACA recipient ineligible to apply for a change in status to lawful permanent resident on a conditional basis if the recipient originally entered the United States from Mexico and is a national of a country other than Mexico. This amendment adds a provision to the grounds of ineligibility that an alien cannot apply for a change in status if they originally entered the United States through Mexico and are a national of a country other than Mexico. The next amendment, number 7, makes a DACA recipient or any alien who has temporary protective status ineligible for asylum unless the alien's claims supporting a credible fear of persecution are more probably than not true, determines that being a deferred action for childhood arrival recipient or having temporary protected status does not constitute membership in a particular social group for the purposes of applying for asylum. Determines that being a deferred action for childhood arrival recipient or having temporary protected status does not constitute membership in a particular social group for the purpose of applying for asylum. Being in the country under temporary protected status does not constitute a targeted social group and should not be used as a mechanism to avoid removal.
Any questions of Mr. Burgess? I just say one thing about your last amendment. I mean, your amendment appears to be attempting to rewrite asylum law. To say that people inside the country that are requesting asylum must meet a much higher burden than is generally reserved for statutory protections from persecution, like withholding of removal. So I don't understand why create an entirely new statutory test for asylum. I mean, just because you have TPS doesn't give you a leg up for asylum, or just because you still have to prove that you have a well-founded fear of persecution. It sounds like you're creating a whole new, maybe I'm misunderstanding your amendment.
No, it's not a new category, but I mean, what I heard over and over again when I was in McAllen this past week was, if we do not reform the asylum laws in this country, we are not going to solve this problem. And that it was a direct request from our personnel in Customs and Border Patrol. I mean, these men and women are overwhelmed at our border stations, and they are asking for our help in order to make the amendment in an effort to make it germane. That's why the wording was struck the way it was. But it is, if we do not effect a change in our asylum laws, it is virtually impossible to deal with the crush of people that are coming across the border currently.
So you would want to change the criteria that if you have a well-founded fear of persecution that you are eligible for asylum. You'd want to. How do you raise that bar higher? I mean, I apply for asylum because I would say to you, if you send me back, I will be killed or I will be tortured. How much more dire is my circumstance?
And yet, Mr. Chairman, we know that of all of those cases where credible fear is asserted, that 90% on closer scrutiny are not accepted.
Well, I don't know that for a fact. I would just simply say this, that to help to deal with the problem that you heard on the border, maybe we got to send more asylum judges down there so these cases could be adjudicated more quickly. Mr. Raskin, you have a question?
I mean, it seems to me that the win-loss statistics don't go to the relevance of the standard. The standard should be whether a person has a well-founded fear of persecution if they're returned to their home country. What would we indeed replace that with? Whether, 10% of the people are getting through or 50% of the people are getting through, what would the alternative standard be?
But as the situation is currently, with 90% of those claims not being judged as satisfactory for admission under the asylum laws, but the cases are not heard for sometimes months or years after the notice to appear is given, essentially you have a de facto entry into this country. Many of those cases are going to be over 4 years old. By this bill that we have in front of us today, that 4 years would make those individuals eligible to be included under the next DACA provision.
So but I think that the gentleman's making an argument for expediting the hearings, for more judges and a more rapid process, right? In other words, I still don't know what the alternative to what that legal standard might be.
The reason for the wording the way it is was to get a hearing on asylum in front of the Rules Committee with this legislation that's before us. Had I put forward an amendment to increase the number of asylum judges, you'd have said it's not germane, and that would have been the end of that.
We could maybe work with you on that on the appropriations process, because I think we should have more asylum judges at the border. I think that'd be
more lawyers,
a really strong bipartisan vote if the gentleman wants to pursue that. Any other questions, Ms. Scanlon?
I just wanted to correct or make note of one thing. This figure of 90% of the asylum cases failing is a really skewed figure that has to do with cases where people are not represented. When people are represented, the figure is much different. One of the problems we have with the immigration system right now is that people are not entitled to representation, so they don't have representation, and we've seen things happen like American citizens have been deported because they were deemed, potentially from another country, and therefore they were not provided with representation, and then they were sent to a country that was not their home. We've also seen people who had valid, credible fear interviews be deported because they did not have counsel, and then they were sent back to their home countries and they were murdered because that credible fear was in fact quite credible. So the 90% statistic is not accurate.
Any other questions of the gentleman? Thank you. Ms. Lesko.
Thank you, Mr. Chair. I have an amendment to the rule to make an order amendments number 3, number 4, number 10 to H.R. 6 offered by myself. No? We're just testifying on my amendment.
Unless you want to just make your case while you do the amendment, it's up to you.
I can make the case when we actually move it, if you'd like.
All right, then I think we're ready to, no other, no one wishes to testify? And now I will yield to the gentlewoman from Florida, Ms. Shalala, for a motion.
Mr. Chairman, I move the committee grant H.R. 6, the American Dream and Promise Act of 2019, a closed rule. The rule provides 2 hours of general debate equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee print 116-16, modified by the amendment printed in the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. Finally, the rule provides one motion to recommit with or without instructions.
Thank you. As we've heard from the gentlewoman from Florida, this rule provides for consideration of H.R. 6, the American Dream and Promise Act, under a closed rule. The rule provides 2 hours of debate equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary, and self-executes Chairman Nadler's manager's role amendment. You've heard the motion from the gentlewoman from Florida. Are there any amendments or discussion? Mr. Cole.
Mr. Chairman, I have an amendment that would actually give this bill a chance of passing.
Okay.
I would like to report an open rule for H.R. 6. The crisis at our borders is something that all of us agree needs to be addressed. But how are members supposed to have their ideas heard when the majority insists on moving forward with this closed piece of legislation? Frankly, we know what that means. We know that it will not pass the Senate, probably won't be taken up by the Senate. We know that the president will not sign it. I think an open rule gives us an opportunity to actually arrive at a bipartisan consensus, prove some things, maybe add some things to the deal with the crisis that's currently going on, both with a security threat and a humanitarian crisis in this piece of legislation. Rather than working with Republicans, however, Democrats have chosen to continue to block members from amending this increasingly partisan legislation. So for this reason, all members should be afforded the opportunity to amend the legislation on the floor.
You heard the amendment from the gentleman. Are there any questions or comments? I have great respect for the gentleman, but I don't believe an open rule would make this bill pass the House. I think it would.
I said it would increase its odds because they are exactly 0.
Well, I think it will pass the House. I don't. Any other comments or questions? You heard the gentleman's amendment. The vote will be on the Cole amendment. All those in favor say aye. Aye. Opposed, no. No. In the opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings. Mrs. Torres. No. Mrs. Torres, no. Mr. Perlmutter. No. Mr. Perlmutter, no. Mr. Raskin. No. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. No. Mr. Morelli, no. Ms. Shalala. No. Ms. Shalala, no. Mr. DeSaulnier. No. Mr. DeSaulnier, no. Mr. Cole. Aye. Mr. Cole, aye. Mr. Woodall. Aye. Mr. Woodall, aye. Mr. Burgess. Aye. Mr. Burgess, aye. Mrs. Lesko. Aye. Mrs. Lesko, aye, Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
I have
Mr.
an
Cole.
additional amendment. Thank you very much, Mr. Chairman. I move to amend the rule to provide that on adoption of the rule, H.R. 6 is recommitted to the Committee on the Judiciary with instructions to add language authorizing resources for the security and humanitarian crisis at the border. I'm very sincere about this. I worked with President Obama the last time we were in this situation, got $3.9 billion added because we had this influx. We are literally going to run out of money this month. Frankly, rings hollow if people complain about how children are treated and won't provide the money that it actually takes to feed them, house them, protect them, give them the medical care that they're entitled to. So I would hope that rather than be involved in a pointless exercise, we would actually add something here that would attract considerable bipartisan support. So I urge the adoption of the amendment.
Well, I would reluctantly oppose the gentleman's amendment, not because I disagree with what he's trying to do. I think the appropriations process is probably the place we're going to do it, or even if there might have to be another emergency bill of some sort to deal with this. I'm not sure that this is the appropriate vehicle, but I respect the gentleman's amendment. You heard the gentleman's amendment. Any comments or questions? Hearing none, the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it.
I'd like to have a roll call, Mr. Chairman.
And the clerk will call the roll.
Mr. Hastings. Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk, report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Mr.
Additional
Cole.
amendment. Thank you very much, Mr. Chairman. Mr. Chairman, I have an amendment to the rule to make an order and provide the necessary waivers for the amendment to H.R. 6 offered by Mr. Diaz-Balart. This amendment provides temporary protected status to certain Venezuelan nationals. The majority actually chose to make an amendment that requires a waiver, avoided granting the waiver by self-executing that amendment in the rule. In the interest of openness and transparency, this committee should grant this amendment the same type of waiver that the Nadler amendment was given and self-executed. Mr. Chairman, this amendment adds to the legislative package the text of the additional measure, H.R. 549, the Venezuelan TPS Act of 2019, that was actually marked up and reported by the Judiciary Committee on May 22nd of 2019. In other words, this committee has already approved this. This measure was marked up by Judiciary, but is absent for some reason from the package. There must have been some change of heart by the Democratic majority if they so quickly changed their mind to not provide TPS status for Venezuela, a country facing a severe political crisis and great political unrest. As this measure was marked up, the amendment should be made in order to give the House of Representatives the opportunity to make their voices heard.
So I would say to the gentleman, I support granting TPS for Venezuelans, and the Judiciary Committee marked it up not too long ago, and my expectation is that it will come to the floor. And probably if you're really concerned about making sure this becomes law, it's better that it comes up on its own than attaching it to this when the gentleman doesn't think this is going to go very far. But I
keep trying to make this more attractive,
I know,
Mr. Chairman.
but
I've given you
but I
three
do
good
think,
options.
I do think we will be bringing up a bill to help Venezuelans who are, quite frankly, faced with a difficult situation in their home country right now.
Well, can I just
Yeah,
add,
absolutely.
just quickly, I thank you for that, and I hope that does come up, and I think it'll get considerable bipartisan support, which it does, when it does.
So I would urge a no vote on this, on this particular bill, in anticipation that we will be dealing with this on its own coming up the very near future. So the vote is on the Cole amendment. All those in favor say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it.
Like a roll call, Mr. Chairman?
The clerk will call the roll.
Mr. Hastings. Mrs. Torres. No. Mrs. Torres, no. Mr. Perlmutter. No. Mr. Perlmutter, no. Mr. Raskin. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 7 nays.
The further amendments. Mr. Woodall.
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment to the rule that would make an order and provide the necessary waivers for amendment number 11 to H.R. 6, offered by Mr. Peterson of Minnesota. That's the amendment I mentioned earlier that provides for the children, the dependents of E1, H-1B, and L visa holders for permanent residency. You said in your opening statement, Mr. Chairman, that the children we're trying to protect come to the U.S. as children and no other place than this as their home. That is exactly who my constituents are, who have these H-1B visas, have been in this country legally for decades, and whose children are aging out of the system with absolutely no pathway forward of any kind. Mr. Peterson has offered an amendment to solve this problem. As Ms. Lofgren mentioned, this is an idea that has the support of over 270 of our colleagues in the House, and I would ask that we give it the same waivers we've given the Nadler amendment and allow it to have a vote on the floor of the House.
So, before I go to you, let me say for the record, on the last call amendment, I should say the amendment was not agreed to. I forgot to say that. Anyway, you've heard, you heard the.
I hope you'll forget to say that about this amendment too, Mr. Chairman.
All those, any discussion on the Woodall amendment? If not, the vote is on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion chair, the noes have it.
Roll call, please.
Clerk will call the roll.
Mr. Hastings, Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole.
Aye.
Mr. Cole, aye. Mr. Woodall.
Aye.
Mr. Woodall, aye. Mr. Burgess.
Aye.
Mr. Burgess, aye. Mrs. Lesko. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
3 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Mr. Woodall.
Thank you, Mr. Chairman. I have an amendment to the rule that would add the text of the to the text of the rule a separate section for consideration of H.R. 586, the Fix the Immigration Loopholes Act. Under an open rule, I understand if you don't want an open rule for the chairman's mark, but this is a bill that's been authored by the ranking member of the Judiciary Committee. It's been co-sponsored by scores of our colleagues. It would go directly to some of the concerns that so many of our colleagues have about fixing the legal immigration system and the asylum system before we go further in admitting more and more new Americans. If we, irrespective of whether the amendment passes, if you truly want to have a bipartisan conversation about how we can do better, because we all share the desire to do better, making the Collins bill, H.R. 586, as a optional amendment would be the way to do that.
Appreciate it. You heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Woodall amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion chair, the noes have it.
Roll call.
Clerk will call the roll.
Mr. Hastings, Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. No. Mr. Perlmutter, no. Mr. Raskin. No. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole. Mr. Cole, aye. Mr. Woodall.
Aye.
Mr. Woodall, aye. Mr. Burgess.
Aye.
Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Mr. Woodall, you, Mr. Burgess.
Thank you, Mr. Chairman. The amendment is number 6 to H.R. 6, and this is the one that adds a provision to the grounds for ineligibility that an alien cannot apply for a change in status if they originally entered the United States through Mexico and are a nationality of a country other than Mexico.
Okay, you heard the gentleman's amendment. Any discussion? Hearing none, the vote is on the Burgess amendment. All those in favor say aye.
Aye.
Opposed, no. No. Opinion chair, the noes have it. Clerk will call the roll.
Mr. Hastings, Mrs. Torres. Mrs. Torres, no. Mr. Perlmutter. Mr. Perlmutter, no. Mr. Raskin. Mr. Raskin, no. Ms. Scanlon. Ms. Scanlon, no. Mr. Morelli. Mr. Morelli, no. Ms. Shalala. Ms. Shalala, no. Mr. DeSaulnier. Mr. DeSaulnier, no. Mr. Cole. Mr. Cole, aye. Mr. Woodall. Mr. Woodall, aye. Mr. Burgess. Mr. Burgess, aye. Mrs. Lesko. Mrs. Lesko, aye. Mr. Chairman.
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments.
Yes,
Burgess.
amendment number 7 to H.R. 6. This amendment would raise the credible fear threshold for deferred action for childhood arrival and temporary protected status holders applying for asylum.
You heard the gentleman's amendment. Any comments? I would just urge a no vote on this. I mean, I strongly oppose it. Changing the criteria for asylum. in a way that I'm not even sure how we would do it, I think is a very dangerous thing to do, and could jeopardize the lives of many, many people who are truly fleeing individualized persecution. So I would urge a no vote. The vote is on the Burgess Amendment. All those in favor say aye.
Aye.
Opposed, no. No. In the opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings, Mrs. Torres, Mrs. Torres, no. Mr. Perlmutter, Mr. Perlmutter, no. Mr. Raskin, Mr. Raskin, no. Ms. Scanlon, Ms. Scanlon, no. Mr. Morelli, Mr. Morelli, no. Ms. Shalala, Ms. Shalala, no. Mr. DeSaulnier, Mr. DeSaulnier, no. Mr. Cole, Mr. Cole, aye. Mr. Woodall, Mr. Woodall, aye. Mr. Burgess, Mr. Burgess, aye. Mrs. Lesko, Mrs. Lesko, aye. Mr. Chairman,
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Further amendments. Ms. Lesko.
Thank you, Mr. Chair. We'll do it this time the right way. I have an amendment to the rule to make an order amendment number 3410 to H.R. 6 offered by myself, Ms. Lesko. You know, I serve on the Judiciary Committee along with some of the members here, and we offered these amendments, Republicans did in Judiciary, and unfortunately they were turned down. Because under the current bill, we're basically allowing people that have misdemeanors for gun violations people that are on the gang member list by law enforcement under this bill, people that had misdemeanor DUI that actually could have killed somebody or injured somebody. We're letting them in. And so my amendment number 3 prevents any alien who has made misrepresentations of falsely claimed citizenship from accessing the relief offered under this piece of legislation. Certainly, I would think that if someone falsifies their application and has misrepresented themselves, they should not be qualified. The next amendment, number 4, adds conviction for driving under the influence or a second or subsequent conviction for driving under the influence to the list of criminal offenses that would exclude an individual under this bill. We've had cases where there have been illegal immigrants that have been driving drunk and have killed U.S. citizens. And so I think this is a common sense amendment that we should not reward people that have DUI that has killed someone or seriously injured them, or they have had multiple DUIs. My final amendment, number 10, adds membership in a criminal street gang as a factor that would exclude individuals from the relief offered in this bill. And again, we debated this in Judiciary Committee. The language is not clear. In fact, in my estimation, it basically says you cannot use the database from law enforcement that lists a person as a gang member as a way to exclude them from this bill and getting a special pathway to citizenship. And I would certainly hope that we wouldn't want to incentivize gang members to come into the United States. And so therefore, I ask my colleagues to vote yes on all these amendments. It's a combined amendment, and thank you.
You heard the gentlelady's amendment. Any comments or questions? Does your amendment say that if somebody is convicted of a single DUI, they automatically are disqualified?
It says that if they are convicted of a driving under the influence or a second or subsequent conviction of driving under the influence, let me get the exact amendment.
I mean, because if someone is killed,
And if
that's
they
a felony.
seriously
Right.
injured someone or they killed someone.
But if I was reading your amendment, it said if someone was basically convicted on a single DUI, they would automatically be disqualified.
If they,
Or does it have to result in, I mean, the way I read it, it doesn't say you have to be result in harming somebody or killing somebody. That's in addition to that.
let me find it, hold on one second, and I will answer it for you.
What?
It says, page 9, under line 19, insert the following: a single conviction for driving while intoxicated, including a conviction for driving while under the influence or impairment by alcohol or drugs, when such influenced or impaired driving was a cause of a serious bodily injury or death of another person.
But I'm correct, then, and if you're convicted of a single DUI, you'd be disqualified. I'm just.
If it influenced or impaired driving was a cause of a seriously bodily injury or death of another person,
Well, isn't that a felony in it? What, in killing somebody?
well, it couldn't be in all states and also could be pled down. I mean, there are instances, so if we do not want somebody that is a DUI driver that has killed somebody or has caused seriously bodily injury to get the benefits of this bill, then I would say we should pass this amendment.
Yeah, I'm reading your amendment.
Mr. Chairman.
Yeah, because all right, yeah, I yield to the gentleman from Maryland.
Thank you, Mr. Chairman. We debated this amendment a lot in the Judiciary Committee, and we ended up with stronger language in the bill itself, which gives the Secretary the power to exclude any alien who poses a significant and continuing threat to public safety related to such a conviction or adjudication, including on the first conviction. But the Secretary could find that unilaterally, then it is appealable in court. But that was what we ended up with. So I think it subsumes the purpose of the gentlelady's amendment.
And Mr. Chair, if you mind, if I remember in Judiciary Committee, there was a discussion on this, and basically it came to some of the factors that Representative Collins brought, is that you can't expect the Secretary, if I remember, it had to be the Secretary, he or she himself, that would determine this. Well, a Secretary is a busy person, so you can't expect this person to rule on all these different cases. And so if indeed my fellow members on this committee don't want an illegal alien that has had drunk driving, who has killed somebody or seriously injured a U.S. citizen or any other person for that matter, to be granted this under this bill, a special pathway to citizenship, then I would encourage you to vote for it.
Yeah, well,
Mr. Chairman?
Yeah, gentlemen.
You just, maybe it's just underscoring the obvious, but that amendment is weaker than what we presently have, because an alien who is covered under the existing language of the legislation can be excluded even without having injured someone. They could be excluded simply on the basis of a conviction. They don't have to wound or kill someone. And your point is the obvious one, which is in the vast majority of cases, if not all of them, somebody who kills or seriously wounds somebody with a car is going to be guilty of a felony, I think, in every jurisdiction in the country.
It's not weak in the language.
So,
Well,
Mr.
if I may, I don't read that weakens the language. You're leaving a discretionary decision up to the Secretary. This makes it mandatory that if somebody fell into that category, they would be excluded. So with all due respect to my friend, the way I read it, this strengthens the language. It doesn't weaken it. You're just giving the decision to somebody who may or may not even be aware of the information or be able to know it. If we can establish that somebody did committed a DUI where somebody was seriously injured or killed, we don't really need a discretionary decision. I think the gentlelady's right. We ought to exclude that person from the provisions of the bill.
Well, and thank you, and Mr. Chairman, if you don't mind, you know, there may be a circumstance where the person hasn't been convicted yet. So maybe they were a drunk driver, they killed somebody, it hasn't been, you know, gone to court yet, and they're still there. So under my reading of this bill and some of the lawyers on this reading of this bill, they could qualify under this. So I just think there has been instances, I think in Arizona actually, where a DUI, a drunk driver who is an illegal, has killed a U.S. citizen. And I just don't think we should be encouraging people to give him a special pathway to citizenship over other people that have been waiting in line, especially if they've killed somebody with a drunk driving or seriously injured them.
But your amendment says on conviction.
Mr. Chairman?
Yeah, gentlemen.
Yeah, again, if I might, we felt that language was redundant of, I think, every state law in the country. I believe that the state laws take care of someone who commits a killing or a grievous wounding of someone with a car. That's a felony offense in all of these states. So if the purpose is to capture people who have not yet been convicted, as the gentlelady suggests, it's not covered by the language of her own amendment. So I'm not sure what it does. Let me just say this on this point, and I think I mentioned this in the hearing, because I lost a favorite cousin of mine to one of these Florida drivers. And the problem of drunk driving is a plague upon the land. As a state senator in Maryland, I led the fight to install compulsory ignition interlock devices on the steering wheels of anybody who's a convicted drunk driver. It's a breathalyzer that you put in your car, okay? So that is a serious attempt, and we had a huge fight with the liquor industry over it. They fought us for years over it. Unfortunately, it became a partisan thing, but we were able to get that through. So in Maryland now, if you're convicted of drunk driving, you put an ignition interlock device in your car. You breathe in a breathalyzer every 20 minutes in the car, and it's a pain, but that saves the public a lot of agony, a lot of pain. That is a realistic and serious way to address the problem of drunk driving, and I'm afraid that your amendment doesn't really do anything to address the problem of drunk driving, which is far too serious to tie up in, a series of rhetorical interventions about immigration. So I yield back to you, Mr. Chairman. That's all I'll say.
Mr. Chair, I think we could debate this, and obviously we disagree. My amendment's attempt is not to solve drunk driving. My amendment's attempt is to say, if you're an illegal alien and you are a drunk driver that has seriously injured someone or killed someone, and for whatever reason, they didn't get to be, it wasn't a felony, I mean, it could happen, or if you've had multiple second or subsequent convictions for driving while you're drunk, you shouldn't be given this special benefit under this bill of being rewarded a special pathway to citizenship. I just think it's wrong, and that's the point of my amendment.
So I think we're going to have to agree to disagree. Any further discussion? And if not, the vote is on the Lesko amendment. All those in favor say aye. Aye. Opposed, no. No. Opinion of the chair, the noes have it. Clerk will call the roll.
Mr. Hastings, Mrs. Torres, Mrs. Torres, no. Mr. Perlmutter, Mr. Perlmutter, no. Mr. Raskin, Mr. Raskin, no. Miss Scanlon, Miss Scanlon, no. Mr. Morelli, Mr. Morelli, no. Ms. Shalala, Ms. Shalala, no. Mr. DeSaulnier, Mr. DeSaulnier, no. Mr. Cole, Mr. Cole, aye. Mr. Woodall, Mr. Woodall, aye. Mr. Burgess, Mr. Burgess, aye. Mrs. Lesko, Mrs. Lesko, aye. Mr. Chair,
No.
Mr. Chairman, no.
Clerk report the total.
4 yeas, 8 nays.
Amendment is not agreed to. Are there any other amendments or discussion? Hearing none, the question is now on the motion offered by the gentleman from Florida. All those in favor will say aye. Aye. All those opposed, no. No. In the opinion of the chair, the ayes have it. The motion is agreed to, and the clerk will call the roll.
Mr. Hastings, Mrs. Torres. Aye. Mrs. Torres, aye. Mr. Perlmutter. Aye. Mr. Perlmutter, aye. Mr. Raskin. Aye. Mr. Raskin, aye. Miss Scanlon. Miss Scanlon, aye. Mr. Morelli. Aye. Mr. Morelli, aye. Miss Shalala. Aye. Miss Shalala, aye. Mr. DeSaulnier. Mr. DeSaulnier, aye. Mr. Cole. Mr. Cole, no. Mr. Woodall. Mr. Woodall, no. Mr. Burgess. Mr. Burgess, no. Mrs. Lesko. Mrs. Lesko, no. Mr. Chairman.
Aye.
Mr. Chairman, aye.
Clerk will report the total.
8 yeas, 4 nays.
The ayes have it, the motion is agreed to. Accordingly, the gentleman from Florida, Ms. Shalala, will manage this for the majority. Without objection, the committee stands adjourned.